With my lord's kind permission, my lord, one medical education matter, NEET results were announced on the 4th. I am not being permitted to participate in the counseling. Therefore, the counseling may start any time. Therefore, my lord, there is urgency. I am moving the matter, my lord.
19th.
My lords,
19th.
by then, if the counseling, if it starts, there will be some difficulty, my lord. That is all. I've got good merit. That's why if I can request my lords to have an earlier date.
Day after.
Oblige, two matters, my lord.
My lord, for the
Fresh matter, your lordship. We have complied all the objections during vacation. We thought it will be coming, that's why we are moving the memo.
It will be listed without memo. Yes.
my lord, petitioner's matter, my lord. This is a PIL regarding life being endangered because of the train moving from Horsemet to Vasco and Londa to Dandeli, my lord. Kindly have the matter listed next week, my lord.
It will be listed. Automatically listed. Yes.
But in WP matter, the respondent ordered for to refund the money, and the last date of August 1810 to
What if it gap, my lord, in the petitioner's residence area, due to which, my lord, the entire area is flooding, my lord. Hence, my lord, it's a urgency, my lord, matter to be taken up, my lord.
Not by memo.
Due
Yes.
to which, my lord, there is a chances of electrocution also, my lord. Already I complied the all office objections, my lord.
We have said no. Yes. It will be listed in course.
My lord. This is the fourth memo I am moving, my lord.
Not possible.
Serial number 28, my lord. Serial number 28, my lord. I am proxy counsel, my lord. Pray for a week time, my lord. This appellant counsel is not well, my lord.
28 is what? Contempt.
Writ petition PAL matter.
PIL.
PAL matter.
PIL. What is PIL?
My lord, I am the proxy counsel, my lord, in that land acquisition matter is there, my lord. Petitioner counsel is not well, my lord. He is admitted at that hospital, my lord. Petitioner counsel is not well, my lord. He is admitted at that hospital. I am the proxy counsel is mentioning that facts of the case.
You are equally well. 2019 matter.
Next week, any date, my lord, Monday or Tuesday, my lord.
5 years old. Or Tuesday. Day after tomorrow.
My lord, Monday, my lord. Next Monday.
Nobody will come except.
Sorry, my lord. 18th, my lord.
18th.
Please.
Lord, serial number 57 and 58, madam. Senior counsel is not feeling well. Short accommodation, madam.
Which number?
Serial number 57 and 58.
Why?
I'm for complainant, madam. Complainant in this case. Madam.
Why you are seeking time?
Senior counsel is not feeling well.
Senior counsel is not available.
Yes, madam.
Why?
Not feeling well, madam.
Not feeling well.
Yes, madam. Short week.
After 2 weeks.
Serial number 64.
64.
64. I filed the impleading application regarding the hospital work, my lord. Any date may be fixed.
Pardon, little loud.
Any date may be fixed, ma'am. 64 serial number.
Taking time.
Please.
3 weeks.
Kind permission. Serial number 1,
Lord,
we mentioned matter. Stachel Pradeep Kumar.
matter was listed on 5/6. This on court, my lord. After hearing, my lord, the matter notice has been issued.
Which one?
Supposed this one, my lord. Supposed to be listed on 18/7, my lord. By mistake, listed.
Supposed to list in 18th or 18th.
My lord, this
18th.
has to be connected along with the contempt,
Contempt
my lord,
248.
248 of 20.
To be listed on 18th of along with contempt.
18th of July.
48 of 2024.
Yes.
18th of July 24.
July.
Please.
All 18th of July. As stated by learned advocate. We don't.
Right.
Contempt matters. Serial number 2.
Would your lordship take up the writ appeal, my lord, which is
Keep on HL 14%.
Lord, the issue is from what date the upgradation, financial upgradation should be given. Lord, our contention was that as far as in the senior administrative grade, the writ petitioner is entitled from 2018. My Lord, whereas the contention of the writ petitioner was from 2009, which the single judge has granted. Lord, would your lordship kindly have a look at the primary order under which this financial upgradation was granted? Lord, that your lordships will find at page number 51, annexure A1. Lord, it's a office memorandum issued by the Government of India in the Ministry of Personal, Public Grievances and Pensions, Department of Personnel and Training. This particular office memorandum, Lord, grants what is called as non-functional financial upgradation. That is if some officer is eligible for promotion but does not get the promotion, then he should at least get a financial upgradation. That was the object behind this office memorandum. Not page 51. If I may read the top first paragraph, not consequent upon the acceptance of the recommendations of the 6th Pay Commission, following orders are issued. Whenever an Indian Administrative Service officer of the state of the joint cadre is posted at the center to a particular grade carrying a specific grade pay in pay band 3 or 4, the officers belonging to batches of the organized group A services that are senior by 2 years or more and have not so far been promoted to that particular grade would be granted the same grade on non-functional basis from the date of posting of the Indian Administrative Service officers in that particular grade. So what effectively it meant is that if an IAS officer officers from the organized group A services will be eligible for similar services by a seniority of 2 years. What is critical, my lord, is that there are certain conditions laid down. The terms and conditions for grant of these financial upgradations can be found at page 54. In page 54, my lord, item number 1, 2, and 3 would be relevant. The non-functional upgradation granted under these orders will be based on empanelment and posting of particular batch of IAS officers in the center. Such upgradation would not be linked to vacancies in the grade. The upgradation granted in these orders will be purely non-functional upgradation, personal to the officer, and it would not bestow any right to the officer to claim promotion or deputation benefit based on non-functional upgradation in such a manner. Third one, my lord, is the most critical, which will fall for your lordship's interpretation. All the prescribed eligibility criteria and promotional norms, including benchmark for upgradation to a particular grade pay, would have to be met at the time of screening for grant of higher pay scale under these orders. So therefore, my lord, our contention is that in order to be eligible for the NFFU, the promotional norms would have to be met. Now, these promotional norms are laid down in the recruitment rules. Now, this particular writ petitioner joined the services in 1987. Lord, he completed 24 years, my lord, which is one of the Lord, last time, Lord, I had undertaken to furnish the relevant rules. Lord, may produce it now, my lords. Lord, the first document is the recruitment rules of 1999, which governs the method of recruitment of the Group A officers. In this 1999 rule, which begins at page 1, would your lordships kindly turn to page 2, where certain conditions are laid down. The writ petitioner claims, my lord, to the promotion to the grade of IG, Inspector General. For that, my lord, right at the bottom of page 2, by promotion, beginning with the words by promotion. Lord, that reads as, from amongst Deputy Inspector General, which rank the petitioner held at that point of time, of Indo-Tibetan Border Police Force who have rendered 2 years service in the grade with total 24 years of Group A service and being in medical category shape 1. But the writ petitioner, having joined the services in 1987, completed 24 years only in 2011. And in 2011, the recruitment rules of 2010 was applicable. My lord, that begins at page number 10. This rule, my lord, stipulated a new condition. The one which begins at page 10, effective from 5th of October 2010, stipulated a new condition at page number 13.
2010,
Yes, my lord, effective from
he became eligible for that higher grade when?
in 2011, because he completed 24 years only in 2011.
Under 2010 rules, he is eligible.
In the 2010 rule, my lord, he would be eligible, but my lord, there is one condition, if I may read, my lord, for your lordship's consideration. Page 13, my lord, there is one short rule, beginning with the words by promotion. From amongst the Deputy Inspector General of the Indo-Tibetan Border Police Force with 2 years regular service as Deputy Inspector General, and, my lord, this is a new condition, who have undergone pre-promotional course or courses as prescribed by the department. So therefore, not since he became eligible after completion of 24 years of service, this condition became applicable to him. But my lord, we provide the pre-promotional course, my lord, to officers who come to the zone of consideration. My lord, he came into the zone of consideration only in 2017. Zone of consideration means if we are recruiting 5 officers, the next 5, 10. So therefore, my lord, he had to wait for about 6 years from 2011 to undergo the training. He underwent training in 2017.
It was never offered.
I'm sorry, my lord.
Training was never offered to them.
Training, my lord, although he became eligible, we did not offer training because, my lord, he was not in the zone of consideration until 2017. When he came into the zone of consideration in 2017, we called him, we gave him training, and with effect from 2018, which is the next year, as per the rules, my lord, we have granted him the NFFU. But learned single judge, my lord.
Why was not in zone of consideration?
Because there were so many other people above him. For the purpose of promotion, there were various other people above him.
Frequently complied to all the requirements of
Ye-
eligibility.
Yes, my lord, I would concede that he had complied with the other requirements. But I must also concede that the training is not at his behest. He cannot demand the training. We have to provide the training.
His judgment also. So
True. But the only reason why we did not provide training is because his turn came up much later, 6 years later.
that is that.
Can I make a submission?
No, my lord, I will complete, my lord, then you can make. I don't want any interference from. My lord, that would fall in your lordship's domain, my lord. I mean, whether by way of equity we should have given him. But my lord, we have followed the recruitment rules. And under the recruitment rules, my lord, his turn for pre-promotional training came up only in 2017. And immediately thereafter, my lord, we have given him the benefit of the NFFU in the senior grade.
So what about this? Undergone the pre-promotional course which is not offered.
We did not offer him pre-promotional training course in 2011.
So when he became otherwise eligible.
Otherwise he became eligible.
At the time of introduction of 2010 rules.
Yes, 2000 in my respective submission, when he completed 24 years.
When?
December 2011.
10.
11, December 2000, because he completed 99 rule requires 24 years of continuous service.
24 years were completed in 11.
December 2011.
At that time, 2010 rules were in vogue.
Yes.
Under that he was eligible.
Yes, but in 2010, unfortunately for him, this pre-promotional course came into being, and we called him for providing that training only 6 years later in 2007.
2010, you offered this pre-promotional course. After 2010.
Yes.
Have you offered him this pre-promotional course?
No, we called him for we provided him the pre-promotional training only in 2017 because
2017.
17.
That he is not at fault.
True, Lord. I must concede that is not his fault. But why did the answer for why did we wait for that long is because he was not in the zone of consideration then. That's the only reason that we have to offer.
I was not in zone of consideration.
There were many officers above him.
You said in 11 he became eligible.
He became eligible, but there were so many other people eligible as well.
There is no ground.
Blood, that's the only reason that we have. That his turn for training came up only then, for the purpose of.
So in 11 he completed 24 years.
Yes,
Then you offered this pre-promotional course in 17.
yes.
So for those 5 years or 6 years,
6
he
years.
was not at fault.
I must concede, my lord, he had, I mean, he could not have demanded the, as an officer, he could not have demanded, he had to wait for us to call. And we called him in 2017 for the training because we followed a certain procedure that he should have awaited his turn. And according to us, his turn came only in 2017. That is as far as, my lord, there are 2 claims which he has made. My lord, that is the first claim. The second claim, my lord, he has claimed
The benefit is subsequent, from a subsequent date it is granted or not?
we have granted from 2017.
2017.
The dispute is now whether we should have granted from 2009. He has claimed from 2009.
Why 9?
Lord, 9, he has claimed because the learned single judge followed a particular office memorandum, Lord, in which there is a illustration given. Please, would your lordship have a look at page 57 in the writ appeal paper book. It is one of our office memorandum. Lord, this is, Lord, earlier I read to your lordship the 24th April 2009. About a month later, we issued one more clarification. Lord, in this, we said a reference is invited to this department OM dated 24/4/2009, which I read earlier, as indicated at point 5,
Page
page 57.
57.
57. My lord, this is the office memorandum dated 21st of May 2009.
Is in Hindi. Hindi.
No. My lord, in my paper book, page 57. My lord, it is inscribed the document as Annexure A2. This is writ appeal 59 of 2004.
Yes.
My lord, that must be the statement of objections. Writ appeal 57 of 2024. Adu Satish, nim kaili iradu, it must be objection. Lord, my volume is much thicker. It runs into, I think the last page is 260.
In the statement of objects.
No. My lord, I am reading the writ appeal paper book. In the writ appeal paper book, would your lordship turn to page
in writ-
57?
57, yes.
Yes.
Yes,
My lord, this is the office memorandum issued by the Government of India, dated 21st of May 2009. A reference is invited to this department OM dated 24/4/2009, as indicated in para 5.5 of para 1, details of the batch of officers belonging to IAS who have been posted at the center in the various grades of pay band 3 and 4 with effect from 1/1/2006, as well as date of posting of the first officer belonging to batches annexed. Necessary action may be taken for grant of higher scale for the officers belonging to the batches of OGA services that are senior by 2 years or more and have not so far been promoted to that grade. Now, my lord, there is a illustrative table which is annexed at page 59. You know, in that, in the first block on top, the last item, item number 8, the batch and level in IAS is 1989 as joint secretary, and the batch of organized group A services to be considered for non-functional upgradation is 1987, that is 2 years senior. So for the IAS officers, the effective date was 18/2/2009. So single judge followed this. The learned single judge followed this, and that is what they claim. Our contention is learned single judge did not look into the fact that the promotional norms also have to be complied with. The learned single judge merely went on this. But if you look at item number 3 in the terms and conditions, the promotional norms also have to be satisfied. Now, the promotional norms required that there should be 24 years of continuous service, which, my lord, the writ petitioner completed only in 2011. And in 2011, the...
And you must give the benefit of 2011.
Yes, my lord. 2011, subject to, my lord, if your lordships hold that he is not responsible for the training, then, my lord, from 2011. But, my lord, our contention is the recruitment rule says he is eligible only upon completion of the pre-promotional training course, which he completed in 2017. My lord, that, my lord, would fall in your lordship's equity domain. My lord, but our submission on behalf of the writ appellants is that we followed the recruitment rules. His turn for the training came up in 2017. He completed it and then we gave it. Yes. And then, my lord, because there are various other officers, my lord, that is as far as his first claim is concerned. He made a second claim that he is eligible for the upgradation under the higher grade. Higher grade, my lord, learned single judge did not grant. He said, you consider, my lord, may I take your lordship to the impugned order, last paragraph. In the impugned order, my lord, at page 31 is the impugned order passed by the learned single judge. My lord, para 12 and 13 of the learned single judge's order, at page 31 of my writ appeal paper book, would be germane for your lordship's consideration. But para 12, if your lordship's got, if I may read, in my view, since the Department of Personal Training has categorically stated that the employees who were working in OGS, such as the petitioner, who had been appointed in 1987, would be entitled for the NFFU from 18 to 2009, under the decision of the union to grant this benefit from 1/4/2018 would be illegal. As a consequence, Annexure G2, insofar as it relates to grant of the NFFU to the petitioner with effect from 1/4/2018, is quashed, and the respondents are directed to grant the petitioner NFFU with effect from 2009, insofar as it relates to the senior administrative grade. Now, my lord, the second part, and consider the grant of the NFFU for the services rendered by the petitioner in the higher administrative grade from 17/9/2018 as a consequence. So, lordships would note that the second part is a consideration. This, my lord, we'll consider and pass an order. My lord, according to us, the writ petitioner is not eligible for this as well, because he's the higher administrative grade that he is claiming with effect from 17/9/2018 is for the post of the Director General.
In 2009, he is completing 24 years. No.
No. He joined in 87.
87.
Not he joined in 87 December. So,
20
therefore, 24 years he would complete in December 2011.
11.
Yes. Which is why we are applying the
So
1919.
what is this? What is the significance of this 18 to 2009?
That is, my lord, the IAS officers. Is the IAS officer is eligible in 2009, 2007. The organized officers will be eligible 2 years later.
And where is the provision for 24 years service?
Lord, that 1919 recruitment rule, which
Promotional law.
what I filed today, just now I handed it to lordship. In that, the very first document is the 1999 recruitment rule.
Yes.
1999 recruitment rule. In this page 2 bottom, lordship will find stipulation of that condition.
44 years.
24 years of Group A service.
By promotion, same.
So, my lord, these are the promotional norms which he should comply.
Yes, 24, total 24.
Yes. My lord, the fact that he has to comply with the promotional norms can be found at page number 54 in the writ appeal. Page number 54 in the writ appeal, item number 3.
Yes, what do
My lord, before that, one more item. There was a dispute before the Honorable Delhi High Court. My lord, earlier from the central government, we took a stand that these are all, ITBP is a paramilitary force. We call it as Central Armed Forces. We said these Central Armed Forces are not part of the organized Group A services. That dispute went to the Honorable Delhi High Court. A division bench of the Honorable Delhi High Court held that the CAPF is definitely a part of the OGS and that they're eligible for the grant of the NFFU. That was challenged before the Honorable Supreme Court, which was upheld. But the issue before the Honorable Delhi High Court and the Honorable Supreme Court was whether the CAPF is part of the OGS or not. But in this, the issue before the learned single judge was the personal eligibility of this writ petitioner. That was not an issue before the Honorable Delhi High Court or the Supreme Court. So therefore, our contention is that he should comply with the promotional norms. He completed 24 years.
Delhi judgment is there in part of.
Yes, my lord, both my lord, Delhi High Court judgment as well as the Supreme Court. My lord, if your lordship would like to have a quick look at the concluding part, page number, it begins at page 69, the Delhi High Court judgment. The concluding part, my lord, is at, or the, what was the issue before the Delhi High Court can be found at page number 74. Page number 74, my lord. They have, their lordships have identified 4 questions. Page 74, para 6 of the judgment. What is NFFU? What is organized group A services vis-a-vis group A services? Whether the government has regarded the petitioners as officers of organized group A services. If yes, whether they would be entitled to NFFU. And their lordships answer, my lord, finally at page 122. Page 122, para 86. In view of the above, para 85. In view of the above, the court is of the view that the petitioners, that is officers in pay band 3 and 4 of the CAPF, have been categorized under the OGAS ever since 1986. Hence, the benefit contemplated in the 6th Pay Commission by way of NFFU to remove disparity between the All India services and organized group services ought to be granted to them. Accordingly, the impugned OM dated so and so and all other letters whereby the petitioner's request for grant of NFFU rejected cannot be sustained. And this, my lord, was carried in an appeal to the Honorable Supreme Court, and that was turned down. The concluding, my lord, part is at page 172. My lord, why I refer to this is not the writ petitioner may refer to this saying that the Honorable Delhi High Court has already held it. But before the Honorable Delhi High Court, these questions, the compliance with the promotional norms was never an issue. There, my lord, it was the larger question. Whether the CAPF can be fall within the domain of OGAS. Therefore, my lord, the summary of my submission would be that the OM of 24/4/2019 stipulates that terms and conditions stipulates that promotional norms have to be met with. The promotional norms are found in the recruitment rules. Recruitment rules of 1999 stipulates that 24 years of service should be there. 24 years was completed with writ petitioner in only 2011. And therefore, my lord, the 2010 recruitment rule also would apply, which once again stipulates that he should complete the training course, pre-promotional training course, which he completed in 2017. Thereafter, we have granted. The learned single judge, my lord, has completely ignored the pre-promotional norms and the requirement of completion of the training. And as far as the higher administrative grade is concerned, my lord, the petitioner is claiming the higher administrative grade of Director General. My lord, that post itself was created after he retired. He retired in 2019. The higher administrative grade itself was created in 2020. My lord, I have produced the copy of the rules under which it was created. So since the post itself did not exist, my lord, he is not eligible for the.
So today, if this relief is to be granted, then it will be equivalent to whose?
I'm sorry.
If the relief is granted to the
DIG, not DG, not Director General, DIG. He retired as DIG.
He will stand at par with the director.
I'm sorry.
He will stand at par with director. No.
He will stand in par with the DIG rank. Not, my lord, the second part which he is claiming from 2018 onwards is to the rank of Director General. Huh? I'm sorry. Additional rank, but rank of the direction, additional director general. That post itself was created after his retirement.
So they said that you did not satisfy the promotional.
Lordship, can I make few submission? The learned ASG was quoting the RR recruitment rule. That is not applicable to me. Why? Because I request the Honorable Court to kindly read the Delhi High Court order. The writ petition, running page number 122. Annexure B. The concluding para says, writ petition, writ appeal, page number 122, running page. Can I read? It says that in view of above, the court is of the view that the petitioner, that is the officers of P3 and P4, have been categorized as the organized services, organized group A services ever since 1986. Hence, the benefit contemplated by 6th CPC by way of NFU to remove disparity between IAS officers and other organized group A services ought to be granted to them.
Now I am referring, this same has been concurred by the Supreme Court. They went for the appeal, they lost the appeal. The Supreme Court has concurred this one. Now I am coming back to the very letter which the Additional Solicitor General, Leonard Additional Solicitor has referred. That is the DOPT memo. It is there as the annexure R4 of my counter, or it is as the annexure A in the writ appeal. It says that what was the condition of the Sixth Pay Commission? What was the Sixth Pay Commission's recommendation? The Sixth Pay Commission said that whenever the IAS officer get a particular grade, all the organized service officers 2 years senior to them, they will get the same grade. It is not a promotion, it is only a financial upgradation. What I am demanding is only a financial upgradation, not a promotion.
In lieu of promotion.
In lieu of promotion, not a promotion.
Therefore, you're supposed to set.
No, sir. Lordship, just read.
It is in lieu of promotion or not, to overcome the stagnation.
Yes.
A cadre.
Yeah, it's a
So
stagnation
therefore,
allowance.
It is benefit in lieu of promotion.
Correct.
And in that sense.
Financial, no.
Okay, listen, in that sense, they say that the prescription is that you must comply with the promotional norms.
I am coming to that. The same order which Leonard AG was referring, annexure A in the writ appeal, page number 51. You may kindly read the paragraph number 3, Roman 3. It says that appropriate amendment in service rules may also be carried out. And further, how it is to be amended, that is also been given by the DOPT in the annexure B, page 60. What was the amendment should have been? He was referring 24 years of service. There is no condition of 24 years of service. That is my point. What was the amendment? It should have been. That is given. The appellate number 3 has given the order dated 15th December 2009. It says, what is the promotion condition? Officers of the junior administrative scale grade with 8 years of regular service. In the grade, including NFST, or 17 years of service. There is not 24 years of service, 17 years of service. As group A post in the service, out of which 4 years regular service should be in the check. The condition was either you should have 17 years of service or 4 years of service in the junior administrative grade. Whereas in 2009, there is no condition of pre-promotion course also in this one. I leave apart to that. I am fully completing eligible as per this direction. This was the direction given by the DOPT. And subsequently,
so this is proposed.
No, this has been accepted by the government of India.
The amended rules are amended.
Rule hasn't amended. That is the issue. That is why I did not get in time. The Lordship, the whole purpose of giving NFFU.
Where are the amended rules? In line of this page 60.
It is their failure. They did not do.
No. Failure not amended.
No, this was the amendment which is to be done.
Suggested. Suggested. Then actually amended or not?
It should be amended.
Should
I agree
be
to that one.
actually-
Rest all department has amended. I have given some answer in my reply. See R7 and R8. If they are not doing, it is a discrimination.
Answer the question. Whatever discrimination or no discrimination. Whether rules are amended pursuant to page 60 by memorandum in line of this, what you are submitting.
They have not done it. Why I am telling? I am giving the reason. Lordship, I am giving the reason. The reason is why they have not amended. Because till 2019, they were claiming that CAPF is not an organized service. That is why they did not amend. Whereas the court has said, the Honorable Supreme Court has said that one, since 1987, it is an organized service. So they made a rule which is not for non-organized service, they are not now applying to me. How can it be applicable to me? It is not applicable. I am from an organized services. The organized services, what is to be rule, it is being given here. This is not nothing less than the Union Cabinet has been approved. Lordship, kindly may permit me to submit. I have the copy of that one. What is the recommendation of this is the Pay Commission, as well as what is the Union of India approved gazette notification. May I kindly. The CPC recommendation is the Pay Commission recommendation. Para 3.312. That was why it has been this provision has been given to Group A. It is given. It says that there was a representation from the organized group, because there is a lot of pay disparity, promotional gap in comparison to the IAS officer. To mitigate that, they have worked out a format. In that it was said that any IAS officer who has been brought to a particular grade, all the organized group A services, those who are 2 years or above, to be given same grade, so that a pay disparity can be eliminated. That was the very purpose for which the NFU has been granted. This has been approved by the Union government, and the Gazette notification was issued on 29th August 2008. In that, the running page 39, last two paragraph, it is clearly says what should be the criteria. It says that whenever any IAS officer of the particular batch is posted in center to a particular grade carrying the specific grade of pay in P3 or P4, grant of higher scale on non-functional basis to the officers belonging to the batches, not for individual batches of organized group A services that are senior by 2 years or more should be given by the government. This was accepted by the government of India. So the learned single judge has strictly well considered decision has been given, and he has come to the conclusion that the very purpose of the NFFU was to eliminate the disparity in the promotion avenues or the pay between IAS and Group A services. To eliminate that, they worked out a formula. As per this formula, I am fully eligible for NFFU at the level of SAG, as well as NFFU at the level of HAG. The learned SAG has mentioned that one, This post was not there. I think he is very economical with the truth because the ITBP Act was enacted in 1992. In that, additional DIG was set, additional Director General is ranked. It is there in the rank structure. I have already produced in my response as in my reply. It is already on record. And they waited for 20 years to make the rule. And now they are telling that one rule was not there. It is after my retirement it was made. So, Lordship, I made a small synopsis of what all are the points which I want to submit. Kindly permit me to submit. As per that, I am fully entitled.
What else we are doing? What else we are doing? Permitting.
See, Lordship, my first submission is that one. The appellant is, first of all, it is a time barred suit, means appeal, because 107 days late they have filed. That is up to the Honorable Court whether to accept it or not. There is a delay of 107 days. – 105 days. First submission is they are challenging the rule of law because there are 3 honorable courts given judgment in favor of me. Everything they are once and again they are challenging it without any reason, repeating the same grounds. So, based on the upholding the rule of law, the NFE may kindly be granted as ordered by the Honorable Delhi High Court, as well as the Honorable Supreme Court and the learned single judge.
Where is Supreme Court judgment?
It is there as Annexure B to the writ of appeal.
Annexure?
B.
Page?
Page. Page number 71 onwards, Lordship, is Annexure E, now 69 onwards. That is High Court and Annexure E. Page number 1 to 3 in the writ of appeal. The operative para is page number 70. Subpara 24.2. The Honorable Supreme Court has said, given the direction that the NFFU, as recommended by the 6th Pay Commission, should be given.
So this, Mr. Kamath, applies? Supreme Court applies?
No, the issue before the Honorable Delhi High Court was the larger issue. Whether
Fifth Pay Commission.
what is NFFU, whether the officers of the Central Armed Forces become part of the OGAS. Here, my lord, here the Supreme Court never said don't examine the terms and conditions, eligibility norms. By applying the eligibility norms, my lord, we have given him from 2018 onwards. Whereas the Honorable Delhi High Court and Honorable Supreme Court dealt with the larger issue. Now we are concerned with the actual eligibility of this particular writ petitioner. We concede that he is eligible, but the question is from which date? By applying the promotional norms. If we apply the promotional norms, he is eligible only from 2018.
Lordship, the learned ASG is telling that they won't amend the rule. They won't allow me to undergo, they won't depute me for the course. Then where is the equity principle, my lord?
We don't, we will find out.
That is what I am requesting, Lordship.
That is what we have heard, learned Assistant Solicitor General, Additional Solicitor General, Mr. Arvind Kamath, assisted by learned Dr. So and so and so. For the appellant. Appellant Union of India
Yes, ma'am.
and learned party in person, Mr.
But Austin Eaton.
So and so, so and so, at length and to the satisfaction of party. At length, reserved for this.
I am grateful.
It is reserved, it will be notified for pronouncement.
Thank
In
you.
board, on board.
Thank you.
If you are outside that, we will see that you are intimated.
No, I am here in Bangalore. Thank you.
I believe he practices here.
I am practicing.
Please practice.
Contempt on that they will notify. Contempt,
My,
they notify contempt on, contempt will dispose it.
because the learned single judge order has not been implemented. Because
The
of
present
that-
contempt petition arises after the judgment and order of learned single judge against which writ appeal number 59 of 24 has been preferred by Union of India, which was heard today and the judgment is reserved. Full stop. In view of the above, presently the contempt proceeding does not survive and the party shall be bound by the final outcome of
Lordship,
I'm grateful.
I
writ
may,
appeal.
I may be permitted to submit this resume which I prepared. Small synopsis which I prepared for.
You know. So then we will ask the other side also to give some. Give some.
We'll file.
Within 2 days?
2 days.
And give copy to them.
We have received it. ಆಚೆ ನಮ್ದ ನಂಬರ್ ತಗೊಂಡಿದ್ದೀವಿ ready will serve. When our synopsis is ready, we'll give a copy.
Seal number 3. Vaishali ikkade.
Complainant, please, your lordship. Orders at page 19, relevant portion at page 21.
Yes.
Relevant portion at page 21, para 4, your lordship. We were supposed to make an online application and thereafter they were supposed to consider it at the earliest. Online application, your lordship, I produced it as annexure at page 29.
They filed the online application. Once the application is filed, we will consider your lordship.
It has been done.
Now we have to consider after the online application.
You verified that they have not filed it. Just you're looking at the direction and saying that application is not. You verified that they have not filed the application.
It's an online application now, because there is a software now, Mojini software for the Podi and Durus. They have to file the application online.
Have you verified that they have not filed it?
No, your lordship.
So, why? Only because there is a direction that the petition shall file application, you are saying that the application is not, without verifying.
We'll verify.
Why? Unnecessary. They are saying that they have filed it.
Then we will consider the application because the procedure has to be
Consider it.
followed.
That is the only thing. We are not
Yes.
here to debate and analyze and
Yes, sir.
the direction. When you will do it?
4 weeks time will be granted.
No, you come with compliance. What is the compliance?
But this is the procedure. This is a Podi and Durus. This survey has to be conducted. Physical.
Durasti and Podi.
Yes,
Ah,
sir.
Durasti and Podi, full stop. The directions in the order dated, now will be strict. Directions in the order dated so and so of learners English. 16th November 23 are with regard to carrying out the Durasti and Podi and Durasti of the subject land. The directions are to be complied with by deciding the application of petition within stipulated time. In course of the hearing today, it was stated by learned advocate Ms. So and so for the complainant that the application as contemplated in the order has been already made before the competent authority. In that view, full stop. In that view, the competent authority respondent shall carry out the direction within the time and in any case within before the next date of posting. Full stop. 10 over to second of July. Well, compliance affidavit now.
No, Your Honor.
Do it. This 23 order of 2023. Yes, next.
The education matters, seal number 4, Yatish, yes.
Lordship, I'm appealing for the petitioner in this case. Petitioners belong to OCI category. They're in 12th standard. They have written KCET exams, my lord.
Petitioner belongs to
OCI category, madam.
OCI.
Overseas citizens of India. My lord, in this aspect, my lord, similarly placed petitioners, my lord, other students have been granted interim order.
What is the controversy?
My lord, now the KCET has given a amended rule stating that only a citizen can apply for the KCET exam and NEET exams. However, my lord, Honorable Supreme Court, my lord, in its judgment has overruled that notification. That notification will apply only for OCI born out of 2021. And this OCI, that rules, my lord, where the only citizens can apply, that rules should be applied only to the OCI who was born after 2021. That has been stated by Honorable Supreme Court, my lord, when the notification was challenged. However, my lord, KCA now also will apply that notification and state that only citizens can apply and OCI cannot apply. And other writ petitions are also pending before this court, my lord, where interim orders have been granted and all the petitioners have written exams.
What is your grievance?
Lord, I may be also be permitted to go along with other petitioners, my lord.
So when you were
Please, my lord.
You are before of 21 or after 20?
I am born in around 2004 itself, my lord. I am born in 2004 itself, my lord.
So you give the facts, not in this way. You may be knowing your matter, but we are not. Yes,
Please,
what are the facts? Let us see.
Please, your lordship may kindly come to page number 32, my lord.
32.
Page
Yes.
number 32. That is Annexure A, my lord, where KEA has issued the notification.
Where is
That
Rule 5?
Type copy is at page number 33, my lord.
Where is Rule 5?
My lord, in page number 34, my lord, eligibility. Page number 34, my lord,
Rule
eligibility.
5?
As per Rule 5, my lord, they are mentioned.
Where is Rule 5?
My lord, Rule 5, my lord, that is comes in the rules, my lord, page the notification.
Where is that? Page.
My lord, I have not placed the rules before this court, my lord.
Then place the rule. Without rules, nothing can be. The very rule you are challenging or questioning.
My lord,
Saying
please,
that doesn't apply.
my lord, please come to notification, my lord, issued
No,
by.
we want rules. We will not proceed further.
My lord, they may-
Very prayer relates to the Rule 5. And you are not producing the rule.
my lord, they have
Tomorrow,
KE themselves have produced in page number 34, my lord.
what is produced?
As per Rule 5, Clause 1 of Karnataka's
No, we want the
selection.
language of Rule 5, not the description of Rule 5. Bring the rules tomorrow,
No, day after tomorrow, my lord.
day after.
Much.
Seal number 5, PL matter. Nagarajana.
You have to file objection for the meanwhile, I'm filing to authorities. One from the
she has been directed to file objections for my petition. my lord. The state has to file objections to my petition. Then meanwhile,
My lord, last date of hearing, my lord since my learned friend had made reference to two decisions of the learned single judge, my lord, that is passed in Hyderabad and in Bombay. According to,
They are in public interest litigation,
yes, yes.
the judgments.
Yes, my lord, they are not, but referred to by the petitioner's counsel himself.
No. So you are producing.
Pardon me, my lord?
Like,
I'm not reducing it. It's the references is made in the writ petition.
I have referred to 4 decisions from the Andhra Pradesh High Court, Kerala High Court, Maharashtra High Court, and our own High Court.
we are neither Bombay, we are neither Kerala.
And
Yes,
that
my
was
lord.
passed by the learned single judge.
No.
This is referred
You know
to.
what we are.
Yes, my lord. And today I may be permitted to produce SC decision also. Supreme Court decision.
An
also.
omnibus prayer cannot be granted. Declare all temples not, no, RTI doesn't apply to.
My lord, that too of a central
No,
act, my lord.
the Supreme Court has
One citation refers to the church.
if your lordship permit, lordship permit, he shall produce the Supreme Court decision in Martanda Verma versus State of Kerala.
What are class A, B, and C?
My lord, with the second prayer, my lord, the entire office of the Right to Information Commission has to be closed down. My lord, may I see the prayer.
Repeal and withdraw the notice. Sibandi. This Sibandi is what?
The notifications.
No, as with reference to temples,
And it
Now
applies,
that you didn't make a mention.
applies to which kind of temple? All temples.
all temples. All temples, all temples. There are 34,000 temples in Karnataka, my lord. Your Lordship, may kindly.
It applies to all temple or particular class of temple?
But not, he says all the temples.
He says, but what is yours? What is yours? Then
Annexuary pertains to
Kerala and the temples coming in under the Kerala, Karnataka Hindu religious and endowments institutions notification.
Yes, yes.
So, Your Lordship, may kindly peruse the Supreme Court decision straight away. Temple state has no control over the temples, either monetarily or physically or materially or administratively. When such is the case, the temple staff can never be considered as public authorities. When they are not public authorities, or the act will not apply. That's my humble submission. It is very clearly stated here by Honorable Supreme Court,
You can't,
and it has been.
you can't make the general proposition. Liberty will be reserving liberty to pursue in individual cases if you find so.
Very well.
That is the right thing, not in general thing that.
No,
Individual, given a case, you may say this is not public authority, this temple, for 1, 2, 3, 4 reasons.
No, there are 34,000 temples, my lord. 34,000 temples.
Whatever, then 30,
No.
file 34,000 cases.
If your Lordship,
Of them are-
your Lordship so permits, I may have to file 34,000 writ petitions.
What is to be filed?
34,000 writ petitions I had to file. If your Lordship's.
It is in a lighter way, you don't file any petition.
No,
You-
I'm a humble submission.
To file any
No,
petition.
kindly, may I take your Lordship through annexures? I have put about 50,
Even these petitions you should not have filed.
no, kindly peruse.
There is, Mister, this is all in lighter way, but this prayer
No,
of
no.
this is, this
No, no,
nature
kind,
cannot be
no,
granted. Omnibus
I may be
prayer, omnibus prayer cannot be granted. If you are aggrieved that particular temple is not a public authority, under the right to information, you file a petition.
No, Supreme Court has already held, my lord.
Now, what is
Temple doesn't come under government.
law? Where is that?
With reference to Martanda Verma, it has been held.
This is Ravindra.
And also, yesterday I could get one more Kerala High Court full bench decision.
So can I have a copy?
This copy, I'll give you.
This is,
I'll give you.
this is about the.
That I have already referred to in my petition.
web-based
But it's
relations.
250 pages.
363,
I
not two.
Yes, yes.
363 pages. It has referred A to Z in that. And yesterday, my lord, in respect of Kerala temple, Guruvayur temple, the managing committee of the Guruvayur had donated for ₹5 crores to poor fund of Kerala government. The Honorable full bench of Kerala High Court has directed the government of Kerala to refund with interest, holding that this particular temple pertains to devotees and the founder, and it is not a government public property. It cannot be utilized. It has, the government of Kerala has been directed to refund with interest. If your lordship permit, I shall produce the authority. It is about 50 pages.
That I've already produced.
Huh? Yeah, Thomas, yeah. It is of the year to 26 May 2022, man. In that it has gone up to the constitutional amendment also, 1972 amendment, everything it has been referred to in that Supreme Court issue.
Nobody files RTI in business of private sector. No, I'm just saying. Nobody files RTI for private sector.
Heard learned, sorry. Heard learned.
Two thirds mechanically, this Kerala High Court. Yesterday I could get. It serves the purpose. Very clearly have. State government can never have control either over the temple or its funds or its assets. It cannot even appoint a managing officer. It's only founder or Shabbat.
This was not a public interest petition.
Pardon?
Was it a public interest petition?
Yeah, it is included in that.
Wow,
One of the appellant is PI, respondent. There are 6 review petitions, out of 1 is PI.
It doesn't deal with the point.
No, may I kindly read it, madam? Kindly take page number 21, my lord. It's short from that. Paragraph number 3.
You want us to go through this judgment? Kerala?
Yes, my lord, definitely it would be enlightened.
Page number?
Page number 22, paragraph number 3, it commences. Actually, it definitely it enlightens.
Which comes under question.
Keep it tomorrow till 11. He
wants to
goes
allow-
on producing several judgments. So we'll at least see that so that order doesn't not go wrong. Give me to.
The Green bench matters, still number 6, Mr. Aditya Narayan.
You're not there, like I.
My lord, I am appearing for respondent number 4 and 5, my lord. I pray for a short accommodation, my lord, to file the objections.
Next witness.
My lord, I'm in your lordship's hands. In fact,
Yeah.
my lord, what has happened is these are C category mines were directed to be, my lord, auctioned by the Supreme Court. And they held, my lord, that on all the permissions, sanctions, approvals granted, my lord, under the EC forest clearance, everything must get transferred. They did not transfer, my lord, we were the successful bidders in the auction. And my lord, they did not transfer the forest clearance. It took us 4 years. Ultimately, my lord, they my lord, levied some penalty, minimum guaranteed amount. Under similar set of circumstances, my lord, the order of this honorable court, my lord, at page 308, and they have accepted it. Whether, my lord, your lordships can set it aside and remand the matter so that they can hear us and pass appropriate order in the background of this. No, all right. I mean, your lordship's hands, whatever. All right. 308. Hmm.
50% demand.
At my lord, page 364 and 365, 50% demand like ours was also made. Ultimately, my lord, in the light of this background of the order passed by this on para 36, my lord, at page 364. There's a simple reading of the orders passed by the Honorable Apex Court with terms and conditions of the notification inviting tenders as extracted herein above would leave no doubt the respondent authorities ought to have transferred FC as a forest clearance in favor of the petition. Contention urged by the respondent authorities that transfer of FC is subject to certain conditions such as fulfillment of conditions by the erstwhile SC with regard to compensatory afforestation, production of 50% notional or after expiry of 18 months, requirement of
What is
payment.
FC?
Sorry.
FC.
Forest clearance.
Forest clearance.
Yes.
Note of the prayer in the petition.
My lord, what has happened is they have, my lord, imposed a minimum guarantee, my lord, of amount of 50%. Like, my lord, even MSCPL, my lord, was imposed that. This honorable court held that you can't impose, my lord, and then, my lord, set it aside. Ultimately, they have accepted this order, and, my lord, MSPL, they have given a, they have waived it also. So whether, my lord, I was wondering, my lord, whether your lordships can set aside the order, remand it, let them hear us, and then, my lord, pass whatever order. Thereafter, we can come, your lordships. Otherwise, again, my lord, objections hearing. Whether a shorter, my lord, course is permissible, possible. My lord, please come to page, my lord, this judgment was accepted. Page 4. Page 5, my lord, on perusal, taking note of the decision of the Forest Department in relation to forest clearance of C category mines of H.G. Ranganagowda, bearing ML number zones acquired by MSPL through e-auction. You are requested to take necessary steps for execution of the lease deed without insisting on payment of minimum guarantee dispatch. Ours, my lord, they have imposed, my lord, that minimum guarantee dispatch of 50%. The impugned order, my lord, sorry.
Why do you want that? Why do you want to file some reply? File it.
Please.
Put on it.
That, my lord, was without prejudice. We have specifically given a letter saying it is without prejudice. Ultimately, my lord, your lordship's judgment will bind them. Anyway, my lord, I am in your lordship's. Please.
Next. Next settled. First, next Thursday.
18th is Tuesday. Thursday is 20th. 20th.
Or else, Lord, last may kindly consider granting till Lord 24th. Yes, 24th.
Monday.
Public.
Lord, 24th and 25th, I have some difficulty, my lord.
26th.
Sorry.
Public.
27th, my lord.
26th.
Please.
Writ appeal matter, CC number 7, the appeal by government.
My lord, I appear for the appellant.
Not there. 4 weeks.
Number 8. PSB Mukanappa.
For appealing, short accommodation.
4
months.
Some date will be given.
Number 9. Mr. Sameer Sharma.
Hearing
I
for
recall
first
this is that
respondent.
matter in which my petition for grant of full salary and back wages was dismissed, wherein no inquiry was held at all after the judgment of acquittal. Lordship had heard us on the previous occasion for some time, coming up today again. Lordship, may please find the impugned order at page 23. The reasoning from in the impugned order begins at page 26.
Yes, what?
Please, this is a case, Your Lordship, wherein no departmental inquiry at all was held by this honorable court on its administrative side. No departmental inquiry was held at all, and even pursuant to my reinstatement, full salary and back wages were not granted for the entire period of suspension. If Your Lordship were to recall, the entire period of suspension is for 5 years, wherein I was suspended from service on 31/10/2010. And then pursuant to the judgment of acquittal, I was reinstated back into service on 10/12/2015. My only grievance before the learned single judge was for this entire period of suspension from service, the full salary and back wages ought to be granted. If Your Lordship were to recall, on the previous occasion, I had also referred to a judgment of a division bench of this honorable court, wherein a similar situation had arisen, wherein no departmental inquiry at all was held after the judgment of acquittal in that case. And this honorable court was pleased to hold that if no departmental inquiry is held at all on the administrative side after acquittal happens, then the entire full salary and back wages for the period of suspension ought to be granted. In addition to this, I had also furnished a list of citations on the previous occasion. Lordship may kindly take that. There is a There's a delay of 9 days in preferring the appeal. Notice has not gone out previously. Notice has not been
The order
ordered.
of the learned single judge from paragraph 11 is very clear, my lord. He is the employee of this institution, and it doesn't augur well.
Now, in my respectful submission, while he might be an official of this honorable court on the administrative side, principles of service law and service jurisprudence apply equally to them. My only respectful submission is I'm placing reliance upon settled case law in this particular matter to state that there is a judgment of acquittal by the trial court. After that, it was well within their remit and it was their prerogative to have conducted some departmental inquiry. However, despite the elapse of around 7 years till date, no departmental inquiry is held at all. In addition to that, one of the other submissions that I would place for your lordship's kind consideration is that in whichever
period of suspension,
5 years, your lordship, I was suspended on 31/10/2010 and I was reinstated into service on 10/12/2015, more than 5 years. In fact, on the previous occasion, your lordship had what had fallen from your lordships was whether subsistence allowance was paid or not. If your lordship were to recall, subsistence allowance in my respectful submission was paid in the sense that 50% of full salary was paid for the entirety of the 5 years. If a lordship were to in fact take the Karnataka civil services rules, it states that after a period of 6 months, an employee is entitled to be paid 75% of the full salary and back, 75% of full salary. However, 75% was not paid. For the entire period of 5 years, I was paid 50% of my salary. Therefore, my respectful submission, in fact, if your lordship were to take the division bench judgment of this honorable court, that judgment also, if I may just point out, the lordship has the memo on the previous occasion I had filed.
Everybody saw the bill, they don't give copies.
Lordship were to kindly take page 17. In fact, I adverted to this on the previous occasion. I'll just give for your lordship's consideration. The short question which calls for determination in this appeal is whether the employee on reinstatement after his acquittal is entitled to the difference in amount of full wages and the subsistence allowance paid between the date of order of suspension till the date of withdrawal of suspension. Lordship may now have page 20. Lordship, I have page 20, that's the operative portion. Page 20 for lordship is at para 8. On reinstatement, the question arises whether the employee who has been undergone suspension is entitled to the difference in full wages and the subsistence allowance paid during the period of suspension. In some of the statute, it has provided with the employer is at liberty to pass appropriate orders regarding withholding the difference in the balance of amount between the period of suspension. In case after acquittal, the employee is reinstated in service, then the my respectful submission is, I have already preferred a representation on 8/4/2019. The lordship kindly finds that, I'll just point out. Your lordship finds that at page 90 of the writ appeal papers. Page 90. This is a representation I had preferred on 8/8/2013. This was 8 days after the judgment of acquittal, wherein I pleaded on the administrative side of this honorable court that there is a judgment of acquittal in my favor. Kindly take me back on service. This was done on 8/8/2013. However, nothing is done. Then on 10/12/2015, 10/12/2015, I have been reinstated. That your lordship finds at annexure A of the writ petition, which is at page 51. Page 51. This is what I had impugned before the learned single judge. If your lordship has page 51, dated 10/12/2015, the order of suspension imposed on Sri G. Shivkumar, watchman working at the High Court of Karnataka, Kalburgi bench, while this office order of even number dated 31/10/2010 is hereby revoked with immediate effect, and the period of suspension from 31/10/2010 to the date of reporting is treated as such. Therefore, the last portion wherein it states the period of suspension from 31/10/2010 till the date of reporting is treated as such. This, along with annexure B in the writ petition, which is a response to a representation that I had preferred on 8/4/2019, requesting grant of full salary and back wages, both that came to be rejected. So therefore, I have made a representation before on the administrative side of this honorable court. Lordship finds that representation.
My lord, that is answered in paragraph 13 of the order of the learned single.
In the respectful Your Lordship, I have made the representation. In my respectful submission, I preferred the representation. Representation was rejected, and that rejection I had challenged before the learned single. My only respectful submission is it is covered by case law. It goes against certain settled law. I leave it to your Lordship. I'm in your Lordship's hands. Leave it to your Lordship. No, absolutely. Nothing like that. Only respectful. Grateful. Grateful.
Grateful. Number 10, Mr. R. Shishidhar.
Petitioner, I am for appellant in this case, my lords. My lords, so writ appeal is filed, my lords. Despite of seeking. Lords, I'm.
Yes.
Lords, before the learned single judge, I am sought for mandamus. My lords, requesting to directing the respondents to conduct the elections for the posts which were kept fall vacant on account of the resignation of the 4 directors. Plus, the third respondent is the Malad Bill Producers Cooperative Society Malads. On 29/8/2023, plus the petitioner and other directors are elected in the elections Malad of the society. Plus, when the election officer Malad fixed the date to elect the president and vice president, and that day Malas, out of 9 directors, 4 were offered their resignations. Malad.
My lord, I appear for the state. My lord, there is an observation at paragraph 15 of the order of the learned single judge.
Yes, 15, yes.
My lord, could I seek for some time, my lord, to take instructions and make my submission?
July.
Obliged.
Consideration of complaints in contempt matters. Seal number 11, Mr. Sampath Anand Shetty.
Yes, I'm for the complainant. Now, to the compliance affidavit, they have annexed R1, the order, which is available at page 10 of the compliance affidavit. Page 10, my lord. Now, in this, my lord,
Page 10.
yes, annexure R1. This, according to them, is a compliance. Kindly see in the first paragraph, preamble. On behalf of Archbishop, who is the complainant, Sri Susairaj and Santosh, on 21/10/2021, submitting a petition to the Honorable Deputy Commissioner. Now the direction is 6/9/2022. Kindly see the direction
Which page you are reading?
at content petition papers, page 16 is the direction.
This is the church matter.
Yes.
Yes.
So you have transferred it so many times.
Yes.
No, no, no.
The
Your Lord-
Archbishop himself.
No, all that, that's what my lord, if your lordship permits me, this order is totally without jurisdiction, not in consonance with the directions of this.
They are not in writ petition.
No, no, you, still my lord, it is a way of evading the directions. It amounts, according to me, it amounts to the contumacious conduct on the part of, it completely goes beyond the directions. Kindly see at page 16, my lord, of the writ this contempt papers, paragraph 4. Consequently, the writ petition stands disposed of with a direction to the fourth respondent Tashildar, Yalanka, to act upon the directions issued by the Deputy Commissioner in his communication dated 1/1/2022 at annexure Q, wherein the details of survey number and the extent of the land also given. And after verifying the original grant register, mutation register, and Sagwal cheat register, passed necessary orders. Now, this has not been done ever since 2022. Now, after contempt is filed, an order came to be passed as per that compliance of that on 8/11/2023, my lord. This is totally, they consider some of the representation prior to this, my lord. That is on 21/10/2021. So direction has not been followed. An order totally without jurisdiction. It is not in consonance with the directions contained, and they are as if it is virtually usurping the jurisdiction of the competent authority. Independent of that, they file a compliance affidavit, which is not in consonance with the directions. So it is a total. And all the, whatever the alienation, what they claim, they state that it is nothing to do with the complainant Archbishop. All that what was the direction was to see the original registers, wherein the even paragraph 4 of the affidavit, compliance affidavit, your lordship may kindly see at page 3, paragraph 4. I humbly submit that several persons have submitted application to the competent authority, Special Deputy Commissioner, for re-grant of the said land. The application of the petitioner submitted to the church has been re-granted. So far as re-grant is concerned, there is no dispute at all. Now, the original register, if it is seen, it is a registration under section 8 of the Enormous Abolition Act 1954. The register indicates the names of the church. All that is, it is different churches, the grant were made. What is sought by the petitioner and directed by this honorable court, the restoration of that in the name of the head of the church. But the Tashildar now goes beyond that too after a lapse of 3 years to 1 year later, he comes to the conclusion that there are certain alienations. We have got, as they have produced, my lord, we have got the encumbrance, which shows nil encumbrance. As for the complainant bishop, church, archbishop is concerned, he has not alienated property. Now, by virtue of this annexure R1 order, they virtually confer title on certain persons who have nothing to do with this property. That is not the direction of this honorable.
Dismissed. No content.
Number 12. Vignesh, where are you?
Lord, I plead for the response.
Lord, the directions of the learned single judge is to pay the award amount. The award is of the year 2017, which is at page number 1313.
Amount is not paid or that?
Amount is not paid. Now the statement of objections is filed stating that they have filed a review petition against the orders of the learned single judge. Because the orders of the learned single judge is of the year 2022. They claim in 2024, after the notice was issued, 4 dates of hearing is adjourned. Now they say, come and say that review is filed.
Review is filed. And Lord, we have challenged the award passed by the land acquisition officer, wherein the award was determined under the right to fair compensation 2013 Act. since the acquisition belongs, is initiated under the BDA Act, the award could not have been passed under 2013 Act. On those grounds, my lord, we have filed, BDA has filed a writ petition challenging the very same award.
What is
Lord,
the award?
In fact, what has happened is, my respectful submission is, Lord, in fact, the total amount as per us also, even
When
if
your
it is,
writ petition or review petition is going to be listed?
Lordship may grant me 2 weeks, my lord, by then I'll get the matters moved, my lord, before the internet.
Lords, my 2017 award.
Learned
And till
advocate.
date, we are in 2024, my
You
lords.
must have chance to pursue review and.
Lords, because your lordship knows, my lord, that review is not a ground for avoiding the contempt. They will have to comply in the event there is anything which happens.
We are not holding that it is a ground.
But your lordships, my lords, let them direct, my lords, your lordships may direct them to pay and recover. If succeed in that, I will give indemnity bond, let them recover. I've got other properties also.
Following are the directions, write down. Contained in order of learned single judge dated 30th November 2022, which are sought to be complied with, and quote the directions, page 13. Page 13, reference tab. It was the grievance of the complainant that the sum directed to be paid, amount directed to be paid has not been paid. Full stop. In response to the grievance stated by learned advocate Mr. So and so for so and so that appeal as well as review both are filed against the orders brought under the contempt jurisdiction. Full stop. Mere filing of appeal or review is no ground not to comply with the directions of the court. At the same time, paragraph, the respondent will be given chance to agitate his case in appeal on merits and exhaust the remedy. It is observed that unless within 3 weeks appropriate orders are complied with, the respondent appropriate orders are obtained in the appellate proceedings, in the appeal, the respondent will comply with the direction of payment of the money.
Please, grateful for lordship's indulgence in the matter.
Put up on 15th of July.
Please, Minister.
Please.
Number 13.
I appear for the petitioner. My lords, this is a petition on the issue of lakes and stormwater drains and their encroachment, my lord. Encroachment of lakes and stormwater drains. Now, my lords, a lot of different orders have been passed periodically by this honorable court. May I now just request on 16/11/23, 2 sets of compliance affidavits were filed by the BBMP. And in fact, my lords, thereafter matter was not considered because on different occasions the matter was listed, but my lords, it was adjourned for some reason or the other. If 16/11/23, there are 2 separate compliance affidavits which were filed. And in fact, I wanted to just point out
1611 compliance affidavit.
16/11/23, 2 compliance affidavits have been filed both by BBMP. One on the issue of removal of encroachment on lakes and one on the issue of stormwater drains. (1611), sir. You have it? Yes. Yes. One is a slightly smaller compilation, though they may look very bulky. The affidavit is only 3-4 pages. If my lord sees the first affidavit, this is by one Shri B.S. Prahlad, just for identification. And if my lord sees on the next page, page 2, para 3, right on top, this is the affidavit by Shri D.S. Prahlad, para 3, right on top. I state that steps taken by BBMP, undertaken by BBMP, do compliance of order dated 4/9/23 on stormwater drains is as stated as under. Now, what they state, my lords, in the second para, the second last line from the bottom, they say that there are about 1134 suspected encroachments, which are newly identified. All of these are from public calls. The information, next page, my lords, relates to all 8 zones of BBMP. A tabular statement of the complaints received and newly identified encroachments from 8 zones is enclosed as annexure so and so. Thereafter, they say, after receipt of this information, the next para, encroached portions were physically inspected by BBMP personnel and identified the survey number in which the suspected encroachments are located. Thereafter, compiling all the information collected zone-wise, the same was forwarded to the jurisdictional Tahsildar with a request to conduct a survey and marking of encroachments. And a copy of letters is issued. After expiry of the timeline provided by the order of the Honorable Court to the jurisdictional Tahsildar, upon the information received, which is 5 days, BBMP has sent reminder letters to jurisdictional Tahsildar to conduct the survey immediately. However, till date, no information is received by BBMP about measures undertaken by Tahsildar. It is stated that once the encroached portion of stormwater drains are surveyed and marked by jurisdictional Tahsildar, further steps towards removal of such encroachments, namely issuance of eviction order and removal or demolition of encroachments, would be undertaken. So, my lords, this compliance is not a compliance. They say we've got information of so-and-so encroachments, more than 1,000 encroachments. And we have directed Tahsildar to survey and mark it. Thereafter, we will do something. Now, my lords, the idea is that timelines were strict timelines. They can't just palm it off from one authority to the other. Identical compliance with respect to lakes. The second bulky affidavit, my lords may see, the spiral bound affidavit, the second one is with regard to lakes. That is by one Shri, just to identify, one Shri Vijay Kumar Haridas. And if my lord sees page 2 of that affidavit, of the second affidavit, the bulky one, my lords, on lakes, of the same date, page 2. If my lord sees, there is a sub para 1. BBMP in its weekly action plan. My lords have found that reference.
Page.
No, my lords. If my lords can see the compilation below that, the spiral bound document. Yes, not the stitch document, or maybe it is the it is an affidavit, compliance affidavit by Shri Vijay Kumar Haridas. I think it is that spiral bound version. My lords have found that?
Yes.
Yes.
Vijay.
Yes. So the first page is that. Second page, if my lords may see, page 2. It says status update as on 15/11/23 is a subheading, and para number 1, BBMP in its weekly action plan. My lords have found that line. BBMP in its weekly action plan had stated that a batch of 10 lakes every week would be taken up for the process of identification and clearance of encroachments. In this regard, BBMP has stepped into the timelines provided till the 9th week, corresponding to the 9 weeks that have elapsed since the date of the previous hearing. The next page, my lords, para 2. In this period, 90 lakes have been covered by the BBMP As mentioned in the stages towards removal of encroachments in the affidavit dated 4/9/23, BBMP has completed the following stages. Stage of identification of encroachments, filing of complaints to the designated authority, request by designated authority to the jurisdictional tahsildar to conduct survey and to mark the encroachments. However, despite regular and repeated requests to the jurisdictional tahsildar by BBMP to undertake the work of survey and marking of the encroachment of lakes, it is submitted that tahsildar has not undertaken the said work, which has disabled the BBMP from proceeding with the further stage as mentioned in the timelines. The copy of complaints filed by Executive Engineer Lakes Division for each lake to the designated authority and the requests made thereafter by the designated authority for each lake to the jurisdictional tahsildar is enclosed. Para 4. Since despite the above request, the jurisdictional tahsildar did not conduct the survey and marking of the encroached portion, the Chief Commissioner BBMP issued a detailed letter to Deputy Commissioner Bangalore Urban, dated so-and-so, narrating the background to the directions issued by this Honorable Court. Letter also stated that the timelines provided therein have not been adhered to by the jurisdictional tahsildar. In this regard, and immediate steps are required to be undertaken. It is stated, para 5, that once the encroached portions of the lake are surveyed and marked by jurisdictional tahsildar, further steps towards removal of encroachments, namely issuance of eviction order and removal or demolition of encroachments, would be undertaken. So therefore, my lords, even, and then all the letters are there. It looks very bulky. Ultimately, this Honorable Court had said, you give the timelines. BBMP said, every week we will clear 10 lakes. My lords, it has been a year. They gave up action plan for 90 lakes. And they throw their hands up, whether it is passing the buck from one authority to the other. Ultimately, the lakes are not cleared and stormwater drains, encroachments are not cleared, my lords. And this is nowhere a compliance affidavit.
In fact, on 21/7/2023, the specific order was passed by Transport in the light of earlier order to come out with a formulated scheme, proper scheme. That is by order 21/6/2023, we made a specific reference. 21st July 2023. By order dated 21/6, we made a specific reference regard to comprehensive scheme. We are not at all satisfied to consider these measures.
Who is appearing?
Respondent for BBMP.
Yes.
Make request once you are.
No, let them.
Some time frame, earlier also this matter is being heard at 2:30 usually. So specific time.
No, let them.
Pending since 2014.
No, but let the BBMP respond
Because
on
they are not
this
doing anything.
compliance.
Now they again monsoon has started.
So AG will come and file policies regarding this. And AG will come and file.
AG is appearing.
The AG will be appearing on behalf of the BBMP with regard to the policy issues. They have asked for some scheme to be implemented, my lord. That my instructions are that the BBMP is working on the policy. So the learned AG will be appearing to submit on this. However, having said that, my lord, there are various orders wherein the BBMP is supposed to also file a status report. Because there are certain lakes that come under the BBMP jurisdiction.
19. What's the 20th, 19th?
In fact, your
Can it be in the, I have some difficulty, can it be in the first week of July, my lords, but with some,
It will go to 9th July.
9th July, grateful. But let them respond on these
let them continue
compliance
with all
and
the work
clearance of
because
the
now
lake.
monsoon has started. They stopped all the work because reasons the election. Now the election is also over.
Would my lords be kind enough to say that let them file an up-to-date action taken report at least by the 9th?
Complaints are raised.
Let them
We'll see.
file that in
After
the
we
mail.
go little deep, then we'll see.
But it is also equal responsibility of the Pollution Control Board also to monitor to that. Because as per the Karnataka Tank Conservation Development Authority, when the authorities also made a party, that's the reason, tank conservation. So they also have their response for these things. Not forthcoming.
9th.
9th July.
Great.
This is number 14.
Ramatullah Kotwal.
For the petitioner in this case, my lord. My lord, whole case revolves around the section 14, the composition of board, my lord. Can I take your lordships to section 14 of the Waqf Act 1980?
14 of
Waqf Act, my lord. Section 14.
Okay.
May I, my lord? The board for the state shall consist of a chairperson, one or not more than two members, as the state government may think fit to be elected from each of the electoral colleges consisting of Muslim members of the parliament and the state, or the case may be the Union Territory of Delhi, Muslim members of the state legislature, Muslim members of the bar council of the concerned state or Union Territory, provided that in case there is no Muslim member of the bar council of a state or a Union Territory, the state government or a Union Territory of administration, as the case may be, may nominate any senior Muslim advocate from the state or Union Territory. In this instant case, my lord, there is only one Muslim member who got selected, elected from the Karnataka State Bar Council, my lord. Your lordship, come to section 14, subclass 2, my lord.
This is yesterday's matter
Please, my lord, with regard
of
to,
members
it's already
covered
been
by one judge, two judges.
covered by various series of judgments, my lord, and even they have filed a
That
public
the
interest litigation.
notifications challenged in those writ petitions are different, my lord.
Even on the,
Lordship, kindly let me read the subclass 2, my lord. May I, my lord? Please. Election of the members specified in class B, subclass 1 shall be held in accordance with the system of proportional representation by means of single transferable vote in such manner as prescribed. Provided that where the number of Muslim members of parliament, the state legislature and the state bar council, as the case may be, is only one, such Muslim member shall be declared to have been elected on the board. In this instant case also, one Muslim member by name Asif Ali Sheikh Hussain is been elected. Provided further that where there are no Muslim members in any of the categories mentioned in subclass 1, subclass 2B, the ex-Muslim members of the parliament, the state legislature, or the ex-member of the state bar council, as the case may be, shall constitute an electoral college. The response number 5 is the defeated candidate, Millard. He was the ex-member of the bar council and the state Waqf board, Millard.
Next.
Millard,
Yes, proceed.
Yes, in the composition, Millard, there are two Mutawallis, Millard, who got elected, Millard. So one of the Mutawalli was died after 6 months of the constitution of this board, Millard. So instead of conducting elections of the Mutawalli constituency, Millard, they have inducted the ex-Muslim member, ex-bar council member as the member of the board, Millard. So that's our contention, Millard.
my lord, the entire issue pertains to the realm of section 14 as to whether section 14 has been complied with or not. Now, when we look at the Waqf Act, my lord, section 14 speaks about the composition of the board. Now, there are various, if I may just explain with regard to the merits, that is one part of it. Even apart from the merits, my lord, the issue has already been dealt with. As your lordship, yesterday I had taken your lordship through the various judgments previously. This similar issue has already been dealt with. However, on the issue of merits and the ambit and scope of section 14, my lord, the constitution of the board of the Waqf, my lord, there are 4 electoral colleges. Now, the first electoral college, my lord, consists of member of parliaments. Now, election conducted amongst the parliament members only. That is the first electoral college. Then the second, this is under section 14. Then the second electoral college, my lord, it consists of your MLAs and MLCs, that is the state assembly. Now, the third electoral college consists of members of the state bar council. Now, this is where the question arises. Now, the petitioner appellant, the petitioner before this honorable court, seeking that the appointment of respondent 5, who is a ex-member, is incorrect because over here under this third category of electoral members, my lord, what has happened is first there were only 2 seats. I mean, 1 seat. That was then increased to 2 seats, and that we'll find in annexure R of in writ petition 14330, my lord. That is the impugned order, wherein it was increased from 1 seat to 2 seats. Now, whether that increasing of 2 seats is permissible in law. So when we look at 14, my lord, the ambit of 14, what it says is, if I may read, the board for the state and the capital territory of Delhi consists of chairman, and the third, that is B, 14B3, my lord, 1 and not more than 2 members. So the state has the authority to have 2 seats or 1 seat. And if we look at section 14B3, it speaks about Muslim member of the Bar Council of the concerned state or union territory. And then it also gives under the provision, it provides that provided that in the case there are no Muslim members in the Bar Council, a senior Muslim advocate of the state may be appointed. Further, if we go on to looking at section 14, my lord, it also provides that where there is no Muslim member in any of the categories mentioned in clause 1 to 3 of clause B, section 1, an ex-Muslim member of the parliament, the state legislature can appoint under the category of Bar Council members. So here what has happened, respondent 5 is an ex-Muslim member, which is provided under the provision under section 14, my lord. So even the impugned notification, which is said to be challenged, it doesn't survive on merit also because it has been done in accordance with law. Having said that, if you look into the compilation of judgments, my lord, which
But adverting to the government advocate's submission, Millard, the question of appointing the second member only arises when there are more than 2 members elected to the Bar Council, Millard. There only 1 member is being elected, then he becomes a member of the board. Second member, appointing a second member arises only when there are 3-4 members elected in the Bar Council, Millard, Muslim members. Then they can appoint 1 or 2, Millard. So that's where they are misreading this provision.
the impugned notification gives the scope for the state to elect 2 members, my lord. That is the annexure R in the writ petition 13769, my lord, page 131.
Page
131 of 13769, annexure R, which is dated 7/9/2020. It says that the electoral college of members of the Bar Council of the from Karnataka state, 1 has been increased to 2, and therefore they have appointed a Muslim and also an ex-Muslim member in accordance to the notification. Having said that, if we look into the judgments already placed before your lordship, my lord, this issue was looked into. They filed, a writ petition was filed 19th August 21, my lord, the compilation which was placed yesterday before your lordship.
This is different notification, Millard, dated 16/12/2020, Millard.
All emanates from the same, my lord.
No, no. They cannot arbitrarily enhance 1 to 2, my lord. It's a central act.
The page number 19, my lord. Page number 19 of the compilation of judgment, order dated 5th October 2020. The impugned order over there are the same notifications. We are talking about notification dated 7/9/2020, 15/9/2020.
They sought liberty to file PIL, my lord.
After seeking liberty to file PIL, the PIL judgment is the next annexure at page 22. Wherein para 3, your lordships read yesterday also, my lord. And
The last 3 paras are the same orders, my lord. The petitioners in that petition, my lord, they are having personal interest, my lord. The person who's elected from the bar council, one thing, MLA and member of parliament, they have challenged before this honorable court, my lord. So that's why at the same time, my lord, the observation of the court, my lord, we therefore decline to entertain the petition as public interlitigation. We, however, make it clear that we have not gone into the legality and validity of the disputed orders and notifications. The petitioners were Asif Ali Sheikh, Anwar Basha, Syed Nasir Hussain. They are members of the bar council and member of the parliament, my lord. So they are having the private interest, my lord. That's the reason that petition is being dismissed.
Continue tomorrow.
just one submission, my lord, with regard to this case.
Continue tomorrow.
Please.
I appear for the petitioner in 14.1 and 2, my lord. I will memo for withdrawal to withdraw the petition number 14.2.
No, they are not coming.
Number 64.
Item for 17. There's some urgency in the matter. Let's put on 13.
The next exam is in November, my lords.
No, July.
Item 17.
Results of the
The previous
petition.
exam was in January, the next exam is in November.
No.
For the urgency, my lord, the next exam is in November 2024, November 2024. So the petitioner has appeared in the main examination November 23, supplementary in January 24. So the next exam itself is in November.
When do you?
Next.
Longer. Longer.
No, my lords, next week, anytime, my lords.
By way of an interim order, results were not allowed to be announced. Now, my lord, the matter was some clarity required to be done.
That
Medical college matter.
Next week, my lords.
what is the urgency? You said no urgency.
Students 1 year. That's the reason.
My lords.
Already is under some psychological depression.
Last time you all said that no urgency, therefore we adjourned beyond.
Next week.
Your
But
lordships,
we heard it twice at length.
with your lordship's kind
Number 16,
permission.
your lordship. 16 is that the government
No.
order to take notice on IA number 2, your lordship. I impeded the
18.
joint commission of police traffic.
18, 19, 13 not possible.
With your lordship's
18,
permission.
19.
With your lordship's kind
Yeah.
permission.
Regarding the reducing the road width by the in Gandhi Bazar main road. I made joint commission of police as a party. That the government will take notice as per proposed response number 5, still number 16.
Those who
Yeah, number
mention from nearer are not prevented.
My lord, item number 18, I've told my learned friend, anytime on 25th, 26th, it can be taken up. I have informed the others.
Serial number 60. Serial number 64, my lords.
Serial number 64, was also mentioning. The property has been identified for establishment of a cancer institute in along
But interim order may be extended in that matter, my lords. Somebody had mentioned in the morning, interim order may be
Code
extended.
officer will give dates, distribute.
kind permission. My lord. So on writ appeal, my lords, 1508 of 23, matter was reserved for judgment on 18/3/24. But that is pertaining to that no confidence motion, my lords, 30 months.
That
term.
will come. Don't mention.
No, please, because 7/7, the 30 months term will come.
We know it.
Yes.
So we held that in the facts of the case, the factor of financial constraint was a good criteria to classify the employees who are entitled to the pay revision and who are not entitled. So resultantly, judgment and order dated 4th July 2023 passed by learned single judge, whereby learned single judge directed respondent 2 and 3 to extend the benefit of 1997 pay revision with effect from 1st January 1997 with consequential benefits in arrears, is hereby set aside. Also set aside the modified order dated 5th December 2023 granting pay scale revision with effect from 1st January 2007. Present appeal accordingly stands allowed.
Obliged.
So review petition, seal number 2, Mr. H.V. Sundareshan, party in person.
In this review petition, can I speak? In this review petition, there is an allegation of suppression by Mr. Amit Banerjee. Apart from what I have submitted in my this, I am also referring to a Supreme Court order with your kind permission. In that it says where mere delayed in page number 8 of 9, it says, therefore, mere delayed reference when the foundation for the same is alleged fraud does not in any way affect the legality of the reference, it says. Therefore, I beg my lords to mercifully condone 52 days delay.
Working out his grievance before the competent court. Go there. The last paragraph of the order under review. You can go before competent authority and work out grievance. What is to be reviewed now?
I know honorable court knows everything and I know very little. If my lord permit me, I only refer to only two documents and one para with two parts. That's all in the review petition. That will show how this suppression has affected the decision of this honorable court to make it as one of per incurium rather than wonderful honorable judges judgment cannot, I should not say that I am an ordinary person, but that order becomes bad in law because of this particular thing. Therefore, if I am allowed, I will show how suppression is affected.
All right, no, we'll issue notice. Notice. Heard, learned party in person, notice returnable on. Third July. 3rd July.
3rd July.
Further reading matter? Okay, Anjana CH.
Nobody is there, you are arguing?
My lord, we have concluded our arguments. After they replied, if there is
then-
anything more to add, we'll file our written submissions.
That's it, you file it.
No, my lord, after their reply, if there is anything more to add, we will file our written submission.
But right now you filed or not?
Not filing.
Both of you. In fact, other day, Honorable Chief Justice told you, whatever submission you have made, give it in writing,
We'll do that.
regardless of their submission.
We'll do that.
If you are remembering. Because we are not remembering, therefore we are. Yes,
I've got my written submission.
then we.
On the first point, Manoj, with regard the short point, the matter pertains to doctrine of pleasure, Manoj, which is interpreted under 19(3) D, Manoj. There are two judgments under the very same act, Manoj, under 19F, Manoj, pertaining to the very same act under 19F. This court has held, Manoj, the power of the state under doctrine of pleasure that they have the power to remove them, Manoj.
Justice Arvind Kumar, Honorable Justice Arvind Kumar's bench.
Not Justice Arvind Kumar, Manoj.
Because the other day, Professor cited Justice Arvind Kumar's judgment also.
And
He quoted.
that is regarding Rajiv Gandhi University. Rajiv Gandhi University.
This is another university.
This is
VTU.
Vishweshwara Technology University, Manoj. Different statute at different provisions, Manoj. In fact, what your lordships were pleased to, point out to us in this page 2, 3 representatives of the government of Karnataka, next page, second page D, Manoj. 3 representatives of the government of Karnataka nominated by the state government, one of whom. So the nomination is by the state government to the government of Karnataka and by the question is when it's a question of nomination, Manoj, the doctrine of pleasure comes in. Therefore, the appointment of the petitioner here in Manoj is at the behest of the chief minister and the higher education minister, Manoj, 1 week prior to the previous government, Manoj. So now what has been done is, Manoj, that appointment has been withdrawn and the fresh appointment has ought to be made, against which the petitioner has ought to file the writ petition. Writ petition has been dismissed on the count, Manoj. There is no vested right or substantial interest of the petitioner. The petitioner, having come through the back door, goes back to the back door, and it is only during the pleasure of the government he can continue, Manoj. In fact, Manoj, various universities either Rajiv Gandhi, VTU, State Universities Act, various others, my lords, this, or Rajiv Gandhi University, this court, my lords, wherever a nomination is made, the pleasure of the government or the right of the government.
When tenure is coming to an end?
Tenure is coming to an end as per the order on 2024, my lords. No, no, sorry, 2025, my lords. No,
December 2025.
I'll give the correct date, my lords.
Solid, still 1 year, about 1 year is there.
It expires with the term of the committee. No,
26.
7/12/2025, my lords. 25. Page D.
That was another case Professor is referring to, the companion case. In this case, it is 25.
Yeah, December, 7th December 2025.
7/12/25.
Can I read that sentence, my
That's
lord?
all right. That's all. The tenure is determined by law.
Please.
Need not be argued much.
Please.
Yes.
Even though the petitioner's appointment, my lords, ultimately may be only for 2 years, my lords, because his appointment is dated is.
Other day, my lord asked, Honorable Chief Justice asked you, how mode of appointment, whether it is nomination or by recruitment, appointment, promotion, how that mode has something to do with doctrine of pleasure. That was the question
Please,
which
my
Honorable
lord.
Chief Justice asked
In
you.
fact,
other day.
there are a series of judgment which has decided that, my lords, where mode of appointment, that is nomination is done without any selection process or calling for advertisement or anything, at the sole discretion of the government. Then, my lords, that is the principle adopted to say it's the doctrine of pleasure, my lords. When a nomination is done without calling for any application, inter se merit, at the sole discretion of the government. In fact, one of the courts have gone to hold that such appointments are political appointments, my lords. And in fact, courts have held, my lord, and such principle of natural justice does not apply. No notice is required to be given, no hearing be given. He has no vested right or substantial right in the post. So therefore, my lords, all these principles in series of judgments have held, my lords. So therefore, his case, my lord, saying that I have a right to continue in the said post, my lords, having held, the courts have held that having no vested right, he is not entitled to continue. Nomination cannot be equated to appointment is one other principle, my lord. I'll just point out, give the compilation proposition. Nomination cannot be equated to appointment is what the courts have held, my lord. One other submission, my lord, what sought to be relied upon the Kerala judgment and the division bench of the Kerala High Court, my lord. That was a case, my lord, where the statutes prescribed mode for removal is different from a nomination. When a statute prescribes a mode for removal, my lord, the statute has to be followed. So there's no other choice. In this case, my lord, there's no, it's a case of nomination, it is not a case of removal. So if we have removed him, my lord, by exercising any of the statutory powers, then you could have said that principle of natural justice was not heard, arbitrary, no reasons have been given. So therefore, my lords, courts have distinguished cases where the acts provide for mode of removal and where
it does not.
Where it does not, and where it only deals with cases of nomination. My lords, in one of the cases, my lords, where there was no communication to the courts have gone in case of nomination, my lords. And one other important aspect in the Kerala High Court single judge and division bench, my lords, court has held that it was not a case of nomination, my lords. In that case, on facts, it was not a case of nomination is what the court have held, my lords. So therefore, relying on that judgment, can I read that relevant portion, my lords?
No, you said, you were succinctly, what all you have argued in the last 7 minutes.
Please.
If the doctrine of pleasure is invocable, where it's a case of nomination as contradistinguished from appointment.
Appointment.
Your first submission.
Please.
Number 2, doctrine becomes invocable if the statute under which nomination is made to a public office does not say anything about the procedure for removal.
Please.
This is number 2.
Please.
Number 3, if doctrine is invocable, it excludes ordinary principles of fairness, etc., like principles of natural justice, hearing, regions to be recorded, etc. These are 3 submissions you are making.
And just to bow down to your lordship, could not have been put better, my lord. In so far as nomination, there may be a provision in a statute, my lord, which speaks about nomination as well as removal. The question is, when is the case of nomination, my lord, if I do not invoke the section of removal, I exercise the doctrine of pleasure that I withdraw his nomination. It's not a case of removal. Removal may be for disqualification, ineligibility, various other reasons which the statutes provide for removal. And when you are removing a person, there should be reasons for its removal, which prescribes under the provision itself, saying that you can remove him for A, B, C, D, E, F, G reason. In case of nomination, as the principle of justice, not only no reasons can be given at all. So therefore, I can just simply sit or withdraw.
In this statute, no provision saying how he should be removed?
My lords, in this statute, my lords, it only speaks about vacating of office, which was read out at 47, in case of resignation, my lords, or where he ceases to hold the office. That is section 47, my lords.
Of VTU Act.
VTU Act. Got extra copies of it. Just got one. Can I got a mark that for that. Uh, 47, vacating of office, any member other than ex officio member of any authority of the university may resign his office by letter addressed to the registrar. Subclause 2, any member of the authority shall cease to be a member upon him being convicted by a court of law for an offense which involves moral turpitude. Filling up of casual vacancies. Then, Manoj, what was other again relied upon is clause 50, Manoj. One other important question my lord said post, my lords, on the last date. If a lordship sees section 12, my lords, speaks about pro-chancellor, vice-chancellor, all that speaks about appointment, my lords. Section 13, vice-chancellor speaks about appointment, section 13. Section 15 speaks about registrar, which speaks of appointment. Registrar evaluation speaks about appointment, section 17. 16, 17, finance officer appointment. But when you come to section 19, my lords, with regard to, there are various nominations by the, for example, my lords, if a lordship sees 19.3 C, my lords, nominated 5% representing industry, business, experts, so and so, nominated by the chancellor. Then D, 3 representatives of the government of Karnataka nominated by the state government, one of whom. Then 5 representatives of the Constituent College not below the rank of principal professor nominated again by the chancellor. F, my lords, is nominee of the UGC. So these are all 19.3 or speaks about nomination, whereas the various other sections speaks about appointment. So here is a clear case of nominee, and direct judgment on 19.3F, Malos, is the judgment of this honorable court in Janardhan Reddy's case versus state of, can I give?
Yes.
That was under RP Act.
No, it's same enactment.
Is enactment itself.
This enactment, clause F. Justice Bopanna's judgment, I'm sorry, Your Lordship, not just.
The other judgment.
on the-
Okay. This is Jagannatha Reddy.
Please, my lord. I've made the synopsis in the front page itself so that it becomes easy for my lord. Dr. Jagannath Reddy, Jagannatha Reddy. Para 12, page, my lord, running page number 15, my lord.
Read appeal again. 594445, 2015.
Running page 15, 1-5, my lord. The judgment starts at page number 1. The premise on which the conclusion has been reached in the above cited 3 decision is that if an order is made by an authority and is not communicated and has not come in effect, there is no likelihood that the same authority may visit such order and change its mind.
Which paragraph you are reading?
1-2, my lord, page 15, my lord. 12, page, para 12, page 15, 1-5. In this case, it was a case of nomination by the UGC under 19.3F, my lord. Can I request my lord to turn to page 3 for a moment, my lord? If
Internal page 3.
Running page number 3. Internal also is 3, my lord. Both are 3. Internal and running page are 3. The Executive Council of VTU, same university, consists of members of Senate in section 19.3 of Vishweshwara Technology University. Though the petition refers to earlier action whereby the petitioner was removed by a systematic order which was challenged before this court and the order being withdrawn during the pendency of the same will not be relevant for the present consideration, and the instead case pertains to subsequent nomination. Presently, the petitioner as well as third respondent are claiming right to be a member of Executive Council as a nominee of UGC under section 13.3F. Now we are concerned with 13.3D, my lords. Para 12, page 15, my lords. Running page and internal page 15. The premise on which the conclusion has been reached in the above cited 3 decision is that if an order is made by an authority and is not communicated and not come into effect, there is a likelihood that the same authority may revisit such and change its mind. As such, uncommunicated order does not create or extinguish a right. The said decision, however, not be of assistance to the petitioner in the instant case, though there is no communication addressed to the petitioner withdrawing his nomination. As noticed in the instant case, nomination is one which is to subsist during the pleasure of the nominating authority. Further, under section 13.3F VTU, there can be only one nominee of the UGC. If that be the position, when the UGC nominated another person and communicates to the concerned, it automatically indicates the pleasure exercised is to nominate a different person to be on the Executive Council, and that action would distinguish the earlier nomination as only one person can be on the Executive Council. Therefore, on the subsequent person being nominated, the earlier nominee is required to accept the position gracefully, as there is no requirement to terminate either with or without compliance of principle of natural justice, like in the case of appointment to the post. So therefore, my lords, it is very clear, my lords, in identical, very same 13.3F while interpreting, principle of natural justice is not required to be followed, and courts have held yes to go gracefully, my lords. In fact,
Two things. One is whether doctrine is invocable is one thing.
please,
If doctrine is invocable, whether these principles, conventional principles are excluded for exercising power under that doctrine is another question.
please, my lord.
So your first question is it is nomination to that body.
Correct.
And therefore doctrine of pleasure is invocable. There being no specific provision in the act for removal is
Please.
your first submission.
So therefore, my lord, principle of natural justice does not apply. And one more thing, the language is to accept the position gracefully, he has to vacate. And and one more thing, page 18, my lords, last sentence. Page 18.
Now, where is a discussion in this paragraph to arrive at that conclusion? Where is the jurisprudential discussion?
It has been discussed, my lord. I'll just.
One sentence, it's a nomination and therefore doctrine is not applicable that way. And if it is doctrine invocability, then exclusion of principles of natural justice.
Please.
Where how president will emerge from this discussion? Presidential value should emerge from the jurisprudential decision, not ipse dixit sentences.
Your lordship may kindly see, my lords, the discussion starts from, contention starts from page 4, paragraph 4, my lords. It goes to the petitioner was earlier nominated to the executive council, so and so, nomination was so and so. On facts, it discussed at paragraph 4. In this case, the petitioner was aggrieved saying that I've been removed without following principle of natural justice. Not only natural justice, the order is not communicated to me at all. Without communicating an order to me once I've been nominated, this is the extreme case where you're sitting there, you don't know that somebody else is being appointed in your place. Even in that case, my lords, while interpreting, when the court has said that it is, your lordship may kindly say the judgment discussed at page 5, Roman 2, my lords. With regard to statutory principles, my lords, BP single has been discussed in page 8 with regard to nomination, my lords. Page 8, Roman 5. Then AM Bhaskar is discussed in page 10, my lords. Para 6. So therefore, my lord, the very same judgments which have been referred to by the petitioner, AM Bhaskar or BP single, all those judgments with regard to nomination has been discussed by the learned single judge, and then come to the conclusion at page 8, page 11, paragraph 8. The question therefore is whether the subsequent nomination of third respondent is invalid in view of that there is no formal withdrawal of nomination not been communicated. Your lordship may kindly turn to page 12, para 9, my lord. At the outset, what cannot be lost sight is that a person to be nominated by the UGC at the first is at its pleasure, and there is no specific procedure contemplated either under the VTU Act or any other method of selection adopted to nominate a person. The person thus nominated will therefore remain on the executive council until he enjoys the pleasure of the nominating authority. Since no procedure is contemplated to be followed either for nomination or discontinuation of nomination, the decision in so-and-so relied upon by the learned council is of no assistance. The said decision was rendered in the circumstance where procedure relating to acquisition was the issue, and in the circumstance where the statute prescribed a procedure which was required to be followed, but the same was not been followed. So therefore, these aspects have been considered, saying that procedures of removal.
How ministers are appointed under our constitutional provision, because it is also under pleasure of the president.
In fact, that
let us see the provisions. If applicability of the doctrine were to be more specific,
please,
whether our constitutional jurisprudence supports that, let us see. Of course, it's a different class is another thing. But doctrine is taken from constitutional jurisprudence, even in English law.
Appointment of an advocate general for a moment. That is,
let us see.
That has been considered by this court insofar an appointment of advocate. Even for an advocate general, doctrine of pleasure applies this.
Therefore, whether that is the reason we are saying mode of appointment pales into insignificance when we are considering invocability of the doctrine. This doctrine arose in English law.
Please.
The English legal history by Jackson. He discusses this machinery of justice. We have borrowed it from English law, where because the king was exercising those prerogatives. Since you are saying, if the mode of appointment, whatever way, mode is by nomination, I will not use the word appointment at all.
So please, no,
If
we
mode
understand.
is
Through nomination.
through nomination, then the doctrine of pleasure would come into.
Please, ma'am.
For that, where is the jurisprudential support for that? Except these judgments where discussion appears to be, it could have been more discussion, etc.
Please, Manoj.
Let us go to the constitutional provisions.
Please, man, I'll go directly to the judgment where the courts have said.
We want to say, even the constitutional provision, subject to what I am feeling.
Please,
I am yet to see the constitutional provision. It appears the word appointment is used in the case of ministers.
Please,
even then doctrine of pleasure is invocable.
Correct.
Therefore, we cannot play much with the mode of appointment appears to be. It's a scope for argument like that. Weaving the matter like that. We cannot argue, we can view. You can argue that way. Let us see the provisions of constitution.
Manoj,
Stress is because it is nomination. Therefore, doctrine of pleasure. For that, very the jurisprudence. Let us see the text of constitutional provisions, whereby appointments are made by Advocate General, Attorney General, the ministers. The word used is appointment only.
Manoj, insofar as.
Let us see the provisions.
164.
And the word nomination occurs in constitutional provisions also. For example, the nominated MPs. Yes, that way. Therefore,
In fact, insofar Article 165, Advocate General of the state.
Yes.
The governor of each state shall appoint a person who is qualified to be appointed.
One second. And to further say that, under Article 310 or 11, I do not know. There also doctrine of pleasure is applicable, a restricted operation, even when there is a case of appointment. It supports an argument, 310. Whether word used is appointment or nomination, where appointment is there, doctrine of pleasure is applicable. It is so held by the apex court. Of course, subject to so many restrictions. Where there is no appointment, but the nomination, even there, the pleasure is not available to you. We'll show you some provisions now.
Manoj, insofar as nomination, the courts have held, Manoj, it can be implied or it can be expressed, Manoj. Insofar as Article 165 is concerned, Manoj, it says the governor of each state shall appoint.
So, the mode is irrelevant for invocability of a constitutional doctrine. It can be legal doctrine also. That way, since your argument is the word employed by the statute is nomination, pleasure doctrine comes into play.
Nomination plus the mode of appointment is the government selects a person. It is not on the basis of inter se merit based on qualification or what. Government appoints a person even while appointing an advocate general or any or minister, Manoj, the appointment is made by the government at its pleasure. In the sense, Manoj, there's no test or whatever, it decides to appoint. So therefore, not only it says appoint, the mode of appointment, as I said, Manoj, is not through an entrance test like Public Service Commission or anything. In the same way, Manoj, there is every case.
In other words, to put it more articulatedly, where whether it is nomination or appointment is preceded by selection. Then you say doctrine is not applicable. Where whether it is appointment or nomination, if it is not preceded by selection process, the doctrine is applicable, appears to be versed.
I'm grateful, Manoj, as your lordship said, is more articulately put, Manoj.
how VC is removed?
Well, we see under the State University Act, I think a retired High Court judge or a Supreme Court judge, an inquiry committee is constituted, person to which under the, I can't remember the section, my lords.
4A.
4A. High Court or Supreme Court? Number. Yeah. In fact, Malos, section 76, subclause 4, 156, Malos, of the Constitution speaks about, in other words, doctrine of pleasure. Malos, if I may just point out section 76. The president shall.
In several places, doctrine of pleasure is enacted in the Constitution.
In the Constitution, Malos, this court gives reference to our appointment of Attorney General 76, subclause 4, Article 156, 165. That is the tenure of governor, attorney general, then 165, the advocate general, Malos, 311, Malos. So therefore, my first submission, because what was argued, Manoj, at the time of exercise of doctrine of pleasure, principle of natural justice need not be followed, Manoj. In fact, Manoj, the second judgment on this is Om Narayan, Manoj. That is one more important judgment, Manoj. I'll just read the relevant para, Manoj, that your lordships will get it at running page 32, Manoj. Running page 32, internal page 254. Just above paragraph 12, Manoj. Placetum, just above placetum B, Manoj. The initial nomination of two women, Manoj. Page 32 on top, Manoj.
Placetum B.
Just above placetum B. The initial nomination of two women members itself dependent on the pleasure and subjective satisfaction of the state government. If the appointments made initially by nomination are based on political consideration, there can be no violation of provision of the Constitution in case of legislature authorizing the state government to terminate such appointment at its pleasure and to nominate a new member in their place. The nominated members do not have the will or authority of any residents of municipal board behind them and may be present in the case of elected members. In case of elected members, legislature provided the ground in the section 40 of the act under which the members would be removed. But insofar as nominated members are concerned, which your lordships were saying, the legislature in its wisdom has provided that they shall hold office during the pleasure of the government. It has not been argued from the side of the respondent that legislature has no such power to legislate the fourth proviso. The attack is based on Article 14 and 15. In our view, the said provision neither offends any article of the Constitution or nor is against public policy or democratic norms enshrined in the Constitution. There is also no question of any violation of principle of natural justice in not affording any opportunity to nominated members before removal or the removal under the pleasure doctrine contained in the fourth proviso to section 9 of the Act puts any stigma on the performance or character of the nominated members. It is done for purely on political considerations. In so and so court wrongly held that the pleasure doctrine incorporated in the fourth proviso so and so was violative of fundamental rights of equality as enshrined in Article 14 and 15(3) of the Constitution. We are unable to agree with the aforesaid reasoning of the High Court. Under Article 14 is duty enjoys so and so. I'll skip all that, my lords. Then if I may request, my lords, in page 33, para 13, just above paragraph 14, my lords, last, just placetum F. Even the highest functionary in the government, like the governors, ministers, which your lordships are pleased to point out, my lord, attorney generals and advocate general discharge their duties efficiently. Though removable at pleasure of the competent authority under law, it cannot be said they are bound to become demoralized or remain under a constant fear of removal, and as such do not discharge their function in a proper manner during the period they remain in office. Thus, in the circumstances mentioned, we are clearly of the view that decision so and so does not lay down the correct law. So therefore, ultimately, my lords, what is held, my lord, in this case also, in case of nomination, they have held it, it is done on political considerations.
Whether the nomination to the Senate, etc., can we say that it's a political appointment?
In this case, what has happened insofar as petitioner, the former chief minister and education minister recommend the name and they have been appointed.
Government does it.
No,
When it attains political character.
No, I'm not saying.
These are all political appointments. We understand.
No, I'm saying even in case of political appointments, my lords. Here, my lords, it is my case, my respectful submission, my lords, it is a case of pick and choose whom the government feels at its pleasure, they appoint, at their pleasure, they can remove them.
So that will it not offend the doctrine of autonomy of educational institutions?
No, my lord, that's why it is a case of the state is nominating their representative in the university. He is one of the nominee. That is why, my lord, they say that in the executive council, he is supposed to represent the government.
How is it a representative character?
Your lord. Yes, my lord. Representative character. Three representatives of the government. In fact, my lordship pointed out on the earlier occasion, three representatives of the government are nominated by the state, one of whom.
Then they become the member of that body or not?
Please.
So they lose the connection with the state government.
Once nominated.
No.
They stand rooted in the body. As the members. Of course, sent by the university. So you can't argue that they retain the character of nominee.
No,
purpose of dealing with them subsequent to their appointment.
No, not that, my lord. What the request?
Are they not independent in exercising their powers?
That is the criteria. Regardless of whether they represent or not, in exercising their discretion, are they bound by the dicta of the government, or as my lord has put it, in their wisdom and discretion, they will decide their functions.
Would they take tips and advice from the university?
My lord, what your lordship may kindly see how it has been done, my lord. There's a representative of the UGC, there's a representative of Chancellor, that is a governor, the state government, my lords, and various departments. So therefore, my lords, when each department represents, my lords, once they go, they act as, they become the executive council. Till they sit there, till they send, there's a representative of government was sent to sit.
Till they were nominated.
Till they nominated, please. Then they represent the executive council. Their position is that, as a lordship's chief justice pointed out, the question is this, my lord. The issue is whether having sent a representative, whether I have a right to withdraw that nomination. say, withdraw. The issue is not whether he is bound to act as per my dictate, my lord. The issue is not been removed for that reason.
Nomination is on record.
Yes, my lord, that is at page number, my lords. Where's the petition code? Uh, 66, my lords. No, not 66, at 71, annexure D.
But this question is not discussed in any of the judgments. After nomination,
That's not the issue before.
whether they lose their discretion to discharge their functions as the statute wants, or they will act on the dictate of the government who nominated them.
Well, that's not the issue before, my lords, my lords.
Perhaps that appears to be most relevant.
No, that's not the issue.
because-
That's not the question raised in the pleadings in the writ petition, answered by the single judge, or that power has been exercised saying that you cannot do it independently. That's not.
No, that question we raise now, because it is not just inter partes. It's a, it has, we are interpreting the a law involving public law elements.
My lords,
Action involving public law elements.
Now,
Your lordship may kindly see page 71, my lord. Then,
Consciously. Then it's a very low effect. How can you say that?
my lords, yeah,
this notification itself probably displaces the doctrine of pleasure.
Please, ma'am.
Last line. The term of office of the members shall be 3 years and expires with the term of the council.
Date is also.
So it can be said that it discards the applicability
No.
of.
the lordship may kindly see appointment, my order says this will apply for
We
100.
appreciate that doctrine of pleasure will operate if to operate. This irrespective of such clause, but still.
Your
There
lordship
is
may,
nothing to say that the university consciously.
Excludes.
no,
Ah,
your
excellent.
lordship, your lordship may kindly see tomorrow, assuming my order says you are appointed for 10 years. If anything, any order can't be read in contravention of the statute. The order cannot be read in contravention of statute. Statute says, my lords, it's it clearly says nomination at the pleasure, my lords. So therefore, when it is it has been nominated, it goes inherent in the nomination that it can be withdrawn at any point of time. When a person has been,
Mr. Advocate General, the doctrine of pleasure, degree of the doctrine goes on decreasing. Once you go in the lower echelons of the posts.
As it goes
No,
higher, you have more
Higher,
pleasure.
more.
Amenable to doctrine, exercise of doctrine. Go
Yes.
lower.
Because the very purpose of the doctrine is that to ensure that the person at the high level. the
That's not-
highest administration.
that's
This-
not-
Because it stems from Queen's English concept.
no, my lord, that is watered down by India.
This concept of governance and dominate and controlling the officers or appointees.
In fact, the king said like that, when he removed Edward Coke, king said, I have appointed you, I will remove you.
I'll
And
go to
what you
the,
say, when you say the king is under law, it is contempt of the palace. This is how Justice King James had said, and his son William also said same thing. See English history.
Manoj, coming back, Manoj, to the order of appointment, the fact that it's our doctrine of pleasure clearly goes to show that Bangalore following members have been nominated. The word used is nominated as government nominees. Manoj, under the provisions of 13(3)D.
We appreciate, so only, can we read both?
So therefore, Manoj, what will have to be relied upon is the statute, not the appointment order, Manoj. The Lordship may kindly see, it says that it is appointed under 19(3)D of the VTO Act. 19(3)D says it's a case of nomination. The mode of appointment is, as already at the cost of repetition, Manoj, at the instance of the former chief minister and education minister, 2 days prior to the election, he has been nominated. So therefore, Manoj, to say give, and the courts have held in case of nomination, there is no vested right or substantial interest. Manoj, to say there is question of no waiver of a right to nomination, Manoj. Once the pressure doctrine can be exercised anywhere because he is appointed under 13(3)D. So, Manoj, that is not the case of the petitioner's pleading also, saying that, Manoj,
Is it that section 33?
19(3)D. 19(3)D. In fact, Manoj, all these aspects have been considered.
Whether all their employees in 19(3)D, are they employees of the government? Civil
No,
servants?
No.
Anybody they can be.
Anybody.
But see that section. Except one. Other two can be anybody.
All.
No qualification.
No qualification. 19(3)A, that's the vice chancellor, then B
You
is
are
secretary.
appearing for?
Yes.
You are for university?
University.
University.
Replace these
Replace, so we are opposing the advocate. in that.
Supporting.
Support, yes.
The petition, appellants.
If any question arises regarding any provision of this, of any status or any statute or regulation, or as to whether a person be appointed, so I am appointed, or is entitled to be a member of an authority. The matter may be referred to the charge.
Who should refer? The word refer is interpreted by the courts.
My lord, but they were,
That's what.
He may himself apply. He that has it, chancellor will decide the issue.
Next slide.
When we so refer to him, it's not
6 members of the council so require, not anybody.
also, my lord, they were appointed while the writ petition was pending. We had already initiated the writ petition.
Therefore, he cannot go.
shall be referred. If there is a forum.
No. Okay. One is reference. There has to be a reference, although section is, that's true. That's true. One robs off his discretion. Another gives discretion. Who is that another? That is the question, because section is truncatedly drafted. With due respect to whoever has drafted, draftsman. But they have, these are all the reference, etc. is not just English words. They are legal concepts, because the reference under section 1014. So these words are not to be taken from dictionary. These are the legal concepts evolved over the years of experience. Therefore, we are not very sure. And the argument can be that even the aggrieved also could have gone. There is one thing.
The matter to be adjudicated by the chancellor. So this text. As to how it has to be done, is another issue.
Whether chancellor is also party to these proceedings.
No, my
Take
lord.
up that contention.
My lord, they were appointed while the writ petition was pending.
Wait. Whether chancellor was a party to the petition.
No, my lord.
Did he take up that contention? This matter should have come to me, not to this court. Then how can you take up that contention?
That was not taken.
It was not.
No, not taken. Not taken. That was not argued, my lord. The section 50 was not pointed out. One other submission.
No, my lord's question remains unanswered. When they are nominated, do they exercise their function on the dicta of their master state who has nominated them? Because you are harping upon the words employed in the section, representatives of the government, or they discharge their functions in their conscience, keeping in view the object of the university. Because courts have said, all the university should be treated not being the notional extension of the government departments. There are such decisions. While courts are interpreting provisions of the university's law relating to universities, the autonomy factor needs to be kept in view.
When they are nominated, till they are nominated, my lord, they are representative to the fact that the executive council stipulates representatives of various persons like the UGC, like the state government, the chancellor. The object of it to have independent, different people from different areas to represent the executive council. So when a person comes from the UGC, he'll give a point of perspective of under the UGC Grants Commission, Malad, what are his ideas? Because the UGC would have nominated a person to put across his views, his ideas, how to run the university. The same way, Malad, when a representative is sent by the state government, Malad, it is puts across, but ultimately once he sits on the executive council, he has to act only at the interest of the university and discharge the function under statute. He becomes one of the members of the statute to act in accordance with the VTU Act. Ultimately, is bound by the Act, is bound to act in the interest of the university in terms of the Act and the rules. One of the issue ultimate for my lords for kind consideration is whether the withdrawal of nominee, whether the petitioner who has approached this court, my lords, has a vested interest or a substantial interest to hold on to the post even after it has been withdrawn. That is the scope of judicial review, my lords, insofar as into understanding of 19(3) D is concerned. Whether the representatives of whom the state government has sent has a right to withdraw his nomination and send somebody else. Is a short point for my lord's consideration. And while interpreting that, my lords, various enactments where there is a case of nomination and a representative, either VTU Act, Universities Act, Rajiv Gandhi University Act, Beggars Act, or any municipal bodies, courts have interpreted, my lords, saying that once the state government nominates somebody, the right to withdraw is there. And you should vacate the place gracefully. The person who has come to the back door goes back to the back door. The rest of the argument, principle of natural justice hearing, stigma is attached, all that goes away. Including, my lords, when interpreting Attorney General, Governor, or an Advocate General, my lords, which is enshrined in the Constitution. Even they are appointed under the doctrine of pleasure. My lords.
Whether any of the provisions in the act employ the word doctrine of pleasure, during the pleasure, etc.
The fact courts have interpreted nomination is.
No,
no,
it's not.
no,
We'll come
it's
to
not.
that one. This
No.
one. Whether the other act.
No, man.
Other act.
No, man.
That also does not.
All
Which is that other act?
I'll just point out, I got all the judgments in other enactments.
Not enactments. Other act, I vaguely remember having employed the expression during the pleasure of the government, governor, etc. I do not know. I may be wrong
No,
also.
there may be one or two statutes which.
The other statute is, which is that statute?
First, I'll go to, my lord.
This is VTU.
which-
The another is the Rajiv Gandhi University Act.
Raju HS. my
Give
lords.
that.
Your lordships may kindly see this called out in the judgment itself. I'll just point out.
No, Rajiv Gandhi University Act only. Whether that word during the pleasure, that expression is used. Why we are saying is, suppose if the state legislature has used that enacted that doctrine in one act, in another act it has not said anything, then different consideration would arise.
That is why, my lords, while interpreting this 19(3)(f) itself, my lords, court has interpreted nomination.
That's right. You have said it. We have understood it also. Now question is,
So that
whether
my words-
no, why that is, there is one opinion of the experts. I think if I am right, it is Sutherland on interpretation of statutes,
Please.
American author. He said, where an instrument of law emanates from the same legislature, which employs that this is like the exclusio ulterius maxim, that way. The exclusio ulterius maxim is confined to one statute. But American courts have said that is applicable even when two statutes operating in the same field are made by the same legislature. Therefore, we wanted to know whether the Rajiv Gandhi University employs the expression pleasure, etc.
Can I request, my lords, page 144 is called out, my lords, in the compilation of judgment. Where did you get it? Section 31, if I may request, my lords.
31 of?
The Rajiv Gandhi University Act, my lords. Thanks. Can I read, my lords?
31.
31. Term of office of a member of a Senate, syndicate and academic council. Can I read, my lords? Term of office of the member of Senate, syndicate and academic council, save as otherwise provided in this act, the Senate, syndicate and academic council shall be reconstituted at about the same time every 3 years, and members of the authority shall, except in case of ex officio members, hold office as members thereof up to the date of next reconstitution, provide no person nominated or elected to any authority specified in section shall hold office
For more than two consecutive terms in such authority.
So the word insofar as nominated persons are concerned, my lords, which comes under section 24 insofar as syndicate is concerned, my lords.
Nowhere in this act, Professor, nowhere in this act pleasure is mentioned? It's not?
Not used. While there are a series of judgment under the Rajiv Gandhi University where nomination is used, right to withdraw, discussing all the judgments, my lords, which was cited in this case, saying that once nominated, word nominated, it can be impliedly read into it, and doctrine of pleasure applies insofar as nominated members are concerned.
Nomination goes with doctrine of pleasure.
Please,
As a matter of norm.
as a matter of law.
Without doctrine of pleasure applying in the nomination. That is also, don't go to the doctrine of pleasure. Since it is nomination,
We have nominated,
discretion
we
is
want to
available with the nominee,
Withdraw.
nominator, who nominated, to withdraw the.
Withdraw the nominee. Please,
We are appreciating, no? But you are supposed to face our query or not?
No. Otherwise, my lord, unless this what is best will not come out.
No, we are only naming that power. Even if we withdraw nomination. Now, what chief appears to say is, you have power to do, therefore you have power to undo also that way, regardless of this doctrine.
Withdraw under general principles.
You are controlling the.
Nominee. One other argument which was sought to be made, my lords, saying that blanket orders ought to be passed, my lords.
How this, in our discussion, doctrine of pleasure cropped up? Somebody had.
No, it was the judgment itself says that.
Judgment. In fact, as your lordship, we need not the right of the nominee to withdraw the nominee. Because you have all these judgments, my lords, what they have read it is the right to nomination, the power to nominate is right to withdraw. That is a pleasure doctrine has been invoked while reading into nomination.
No, my lord was asking, why at all we travel to
No,
that
so far.
constitutional we could have gone like
A simple principle, nominee's right to withdraw the
power
nominee.
power to do, therefore power to undo that way.
General Section 21 of the General Clauses
General
Act.
Clauses Act.
Section 21 of the General Clauses.
In American courts.
That is simple, more
that's
simpler
all.
than that.
Power to appoint includes power to withdraw.
I send somebody as my representative.
I want to call him back.
Ask him, come back now. Come back.
Come. Actually, if you come to think about it, you don't have to travel far.
The university can't say that, no, the university can't say that.
I will not send them back.
General clause.
Only question is whether it should be after notice.
Excludes all those conventional restrictions.
In fact, the court says court has said it need not be communicated also. Insofar as this, it can.
It is the other name of doctrine of pleasure.
Whether we name the child or not, child is there. That way. Other day you argued.
All the government employees
across the earlier.
Not-
One president got appoint one of his candidates after so that man shot the president down. After the president was shot down, they introduced the regular system of but thanks to the 1857 why we introduced 18 it was not even introduced in June. Only 10 years ago later 1850 UK law. And after the president was shut down in very council this point. Here they are retaining in a very limited narrow area where the government wants its representative and it is not that power. No qualification, no notification. Article 14 is not, 16 is not.
No, if their tenure is subject to so much discretion of the government, then how they will function as independent? Because that question has something to do with my lord's question. Do they? That question.
I will answer this. In fact, the statute itself. That means just examine the scheme of the act. Just I'll point out from the scheme of the act whether they will continue to be representatives of the government or refuse to be.
Well, in fact, I read out that paragraph where the Supreme Court has said, it doesn't mean that they work under fear. I'll just read that, my lord. Even the highest functionaries in the government, like the governor, minister, attorney general, and advocate general, discharge their duties efficiently through removable at the pleasure of the competent authority under the law. It cannot be said that they are bound to become demoralized or remain under a constant fear of removal, and as such do not discharge their function in a proper manner during the period they remain in office.
There, president does not do it in individual capacity. Marooram versus Union of India,
No,
1980 Supreme Court. He does it on the advice of the Council of Ministers headed by the Prime Minister, headed by Chief Minister, as the case may be. Therefore, he need not have that fear. But here, if as my lord said, if they are independently exercising their powers as members, regardless of they being representatives of the government, then it has some most relevant bearing it will have on the issue. Otherwise, we may render the university, going by other extreme.
No.
We may render the
Tomorrow
university
the government comes to know something about that, they are represented.
as a department of the government. That is not the object.
No, that's not our case also, Manoj. Tomorrow.
But because section, I think the autonomy is recognized by the apex court in a series of decisions.
For example,
autonomy of universities.
I'm not I bow down. Tomorrow there's something against the representative which I sent to the university, Manoj. I find out that he's not fit to sit in as an executive member of the university. I have reasons that he is not credible. I have the right to withdraw his name, or he's not been functioning properly. So therefore, my lord, the question of the person who nominee, right of the nominee to continue or not to continue, should be left to the discretion of the nominee, my lord. That is why the courts have also held the scope of judicial review is very, very limited in case of scrutiny as to withdrawal of nomination of under withdrawal of nomination.
And it may be possible that in the instrument of appointment, nomination, whatever you call, from itself you can get the clue whether it is a doctrine of pleasure exercised or not. There's some appointment before 3 years, like here.
Term is
Appointment
prescribed.
3 years or 60, or the appointee attains the age of particular years.
Attaining age of year,
Whichever
60
is
years,
earlier.
50 years.
And the ideal kind of incorporation of doctrine of pleasure is that appointment until further order. That will be a doctrine of pleasure.
Whereas for-
And any time order can be passed. You can call.
Because we said until further order.
So this mentioning of 3 years, therefore you are telling you that mentioning of 3 years. has
The
some indication.
notification itself.
So therefore, I'll point out your lordship, wherever 3 years is mentioned also, which is withdrawn before 3 years, courts are upheld. I'll point out those where your lordships are pointing out, even though the appointment is for 3 years, the right to withdraw before 3 years is there. That is the doctrine, nomination, doctrine of pleasure. My lords are saying, even though the appointment order says, even though
Might be indicated. Somebody says that until further order. It is the other name of doctrine of pleasure.
doctrine of pleasure.
Not that if it is 3 years, you can't
remove,
but
Remove.
then the
Other
procedural
considerations,
things, some rights,
being
natural
heard,
justice.
etc. No, my lord's question, why, how that doctrine of pleasure ordinarily treated as a constitutional doctrine, the doctrine operating in constitutional law, ordinarily, unless enacted in a statute. The courts have treated, that survey of judgments gives that impression. How that argument cropped up actually, as my lord said, if we could decide, we have power to nominate, therefore we don't want our nominee to continue, we are withdrawing him. But it could have been end of the matter, to put it simplicity. Other considerations may be there. Why the case traveled to this constitutional doctrine,
Because
even in the absence of any indication in the statute, where statute wants, it can enact a doctrine,
Because
subject to fairness, etc.
Because when there are judgments, my lords, of courts where governors were withdrawn, the judgments cropped up, my lords, when constitutional appointees were withdrawn, like the governor.
That we can understand,
So-
because very constitution it is.
So
there.
therefore, while lawyers citing insofar as statutory appointment, they cite those constitutional appointment, and the court distinguishes saying that they are not applicable.
Many
BP
times,
Singh.
Many times, by the ingenuity of the arguing counsel or the discussing judge, we take constitutional doctrines to the realm of Cattle Trespass Act also. That happens. But very scope, as my lord said, very scope for going for higher things. When these things can be settled, there is one, in fact, Shirvai in 4th edition in constitutional law. He says, if you can decide a case without touching constitutional law, explore that possibility first. If not possible, travel to that. He has said that. And supported by 1 judgment of Justice Quire of Federal Court, another judgment of Justice Vivian Bose's judgment. He has culled out those principles. When at all court should raise the constitutional issue. Court need not go to constitutional issue unless it is inevitable for adjudication of the least set acts. Which my lord said. Yes,
The right of the assignee to withdraw, nominee to withdraw. Six.
So there, at that level, you argue
These doctrines, not in this, these things, means, we wanted to know.
We
as
are
my
not
lord
in
wanted.
that way belittling the thing.
No,
but
we are not. We wanted to know,
Ah.
why at all it, that's what the question of my lord was. Why
Simply
at all
just-
this went to this doctrine of constitutional doctrine?
Don't create problems and try and solve the problem.
That, He's saying there is a saying, which professor is saying, he went to pray in the, do namaz in the mosque fell down on him.
Just 2-3 judgments I would just like to point out, my lord. Your Worship, can you take the proposition list, my lord? I'll just go quickly run through the thing, my lord. Page 2, my lord, the first sheet, second sheet, my lord.
You were right up.
My right up, my lord, of the judgment. Lordship, I'll continue some other, because my learned friend also has to.
Professor also has
I
to.
will have to. I'll just run through this, my lords. The second provision, reasons need not be given while exercising doctrine of pleasure, my lords. Third proposition is doctrine of pleasure can be implied. Then, my lords, nomination is by very nature selection process is that they do not have a vested right or security of tenure, my lords. Insofar as nominations, that is proposition number 4, my lords. The Lordship, I got the written submission. Can I request the judgment compilation?
Yes.
Judgment come.
Compilation.
The page number 2, proposition number 2, in the first second page. Not the judgment, the note which I have given itself.
Yes.
In the judgment compilation, second page. Judgment
compilation.
Judgment. At the right at the bottom, proposition number 2, reasons need not be given while exercising the doctrine of pleasure. One other judgment, can I request my lord to kindly turn to page 93 for a moment, my lord. 93 for a moment. Paragraph 49. Paragraph 49. Consequent to the direction of the state government, the Mysore University has issued a notification dated so and so, and the two other members of Syndicate Mysore University. The obviousness of the matter is such that I cannot accept the submission urged on behalf of the petitioner that they are non-nominated for political consideration. The situation cannot be described as more candid objectively, but the apex court has said that in the case of state of UP, those who come by the back door go by the same door. The apex court has held that the person appointed by arbitrary procedure cannot challenge the termination of their service on the ground that the same being arbitrary. Their introduction itself being the product of operation of the spoil system, no public interest is involved in saving their appointment. Similarly, the division bench in the court of Kushal Qureshi has also be of no assistance for the petitioner. In paragraph 14 of its judgment, the need for existence of reasons is made prerequisite for removal of nominate matter only if the challenge to removal is based on malified excess of power. No foundation is laid in the memorandum of writ petition to show that the impugned orders are passed as a result of malicious or hostile so and so. Then last is no para 53. The petitioner have no legally vested right to demand that they be continued as a member of 60 for a fixed period of 3 years. The petitioner are neither elected nor appointed.
Whether there also 3 years was stipulated.
Please, Manoj, can I request, Manoj?
In that order.
Please, Manoj.
Because once the order of appoint notification stipulates specific period.
So
then the invocation may be possible of doctrine, but
page 62,
many considerations still arise.
Page 62, Manoj. Page 62. Para 12, Manoj. Page 62. Para 12. She so and so submit the impugned order withdrawing the nomination of the petitioner to the syndicate of the respondent is passed on account of change in government in the state. He submit the first time in the history of the state such a sweeping withdrawal of nomination has been made. He submit there is no nexus between the exercise of power by the state government to withdraw the nomination and the object which is sought to be achieved by the state government nominating the petitioner in the category of eminent educationist under section 28(1)(g) of the said act. He submit that the petitioners are not nominated for political consideration. They are nominated and they are eminent educationists. When their nomination is for non-political reason, they cannot be removed for political reasons. She so and so. Para 13 submit that the nomination of the members under so is for a period of 3 years. It brings to the notice of section themselves do not specify the term of the fixed section of term can be found in section. He submits the said section as should read as under. My lords, even in case of period of 3 years, my lord, that can be withdrawn. The finding is, my lords, it does not, ultimately, the person who come to the back door have to go to, there's no proper selection process, my lord, and no public interest is involved in protecting them, saving their appointment. And there are series of judgments, my lord, even though if it is for a period of 3 years, in all, my lord, it's for a period of 3 years, they're not, when it is withdrawn, they cannot have say that my appointment order says for a period of 3 years. That is the whole case, my lord. In fact, judgment after judgment are there, my lord. If I want, I can just make a chart. Even the next judgment, my lord, you can, para 19. Next, can if I request, my lord, page 112. Is under the Karnataka State University Essay Act, you know, reading section 28 and 29. Can I request page 123, my lords? Page 123.
If the Honorable Justice Pandit Saab followed the Deepti judgment.
Deepti Baba judgment. One important sentence, my lord. The petitioner were well aware on the date of the nomination that the nomination would continue during the pleasure of the authority. Therefore, my lords, the person who's being nominated, para 1 page, running page 123, para 12, my lord. Last sentence, my lord. BP single Uday Kumar, all this.
Section 39 enacts doctrine of pleasure. This is which act, Mr. Shetty?
This is Karnataka State Universities Act.
Therefore we are asking. Therefore I said, whether any other law operating in the field of a university, etc., employs, suppose if the doctrine of pleasure, this arises because of my lord's question, why at all we travel to doctrine of pleasure when the act does not give scope for that, whereas this act gives scope for that.
Correct.
There we can argue doctrine of pleasure, etc. The intention is, the legislative intention is very clear. It is the same legislature which has enacted these 3 statutes under the very same entry, in the concurrent list perhaps, where same legislature makes different legislations in the same field of legislation and employs different terminologies. Then American courts, I think Justice Neely of American Supreme Court, State Court, Justice Neely, very famous judge whom Supreme Court has referred in 3-4 judgments. He says, where under in the same field of legislation, if the same legislature makes law employing different terminology, then different intention should be presumed.
Please, Manoj.
He says in a very beautifully. I'm not reproducing. I'm saying how I have internalized that view. Yes, see, where this question arises, we are again repeating, because my Lord asked, my Lord Chief Justice asked, why at all you brought into force this doctrine of pleasure at all?
I did not bring
No, this means
the petitioner. No, the petitioner argued.
The significance of arguing.
That
is.
So therefore, my lord,
That
no, as your lordship is right, here it is explicit during the pleasure. The language is explicit.
Still another line looking at it. Now there is a power to nominate. And the section says 3 years.
Please.
That power is exercised nominating a person for 3 years.
3 years.
Expressly. Now can you back out from that? In order to back out, you must have the provision like in 39.
Not, that is not required is what the Supreme Court and this honorable court has held, Manoj.
No, because, no, we have seen that judgment which you are now referring to. Half a dozen times I have read that judgment. That was not a case where under the same field of legislation, different legislations where statutes were made by the same legislature. That was not a case there.
Manoj,
Please see that judgment.
No,
I
Your
have read
Lordship may
that
kindly
judgment half a
see,
dozen times.
let Your Lordship may kindly appreciate where the interpretation, where the word during the pleasure of the nominating authority is not there, assuming it is not there, like in section 39, this court as well as Supreme Court has held.
Still it is available.
It is a doctrine of pleasure, so it need not state, it is implied.
Can we apply the doctrine of reading now?
No,
Where
Manoj.
it is not mentioned.
No, there are judgments of this court interpreting the very same provision and other provisions, Manoj, saying.
That we are appreciating what you are.
So therefore, Manoj, when the Supreme Court has held the fact that it is nominated, it is like, what your lordships are saying is when it just because it is explicitly mentioned here, it doesn't, and there is not expressly mentioned in other statute, it ceases to be a doctrine of pleasure. It doesn't cease to be a doctrine of pleasure. Or the right to withdraw is not taken away, even if it is for a fixed period of 3 years. My lord, the language, as your lordships are aware, my lord, language, some language used in different statute is different. Here, my lord, it is only made explicit. In fact, your lordship may kindly turn to page 130 for a moment, my lord. 130, division bench of this judgment, my lord. This is with regard to the word, again, division bench judgment, with regard to Rajiv Gandhi University, my lords, where the word during the pleasure is not there. Lordships will get it at page 130. The judgment starts at page 146. 146, para 31. 146, 31, the term of office of a member of Senate, Syndicate and Academic Council. My lords got it, Manoj? Page,
Yes.
Page 146, para 31. The term of office of a Senate, Syndicate and Academic Council, save as otherwise provided in the Act, Senate, Syndicate and Academic Council shall be reconstituted at about the same time every 3 years, and members of the authority shall, except in case of ex officio members, hold office as member thereof up to the date of reconstituted, no, provided no person nominated or elected to any authority specified in so and so, so vacation of office. So therefore, the word nominated here has been interpreted, Manoj, which your lordships will get it at page 148. Can I one?
No, in 48, there is no such word at all.
148 para 10, Manoj.
48.
Intern, please, Manoj, running page 148, para 10. Manoj, got Manoj?
Yes.
Para 10. Section 31 of the Act provides the Senate, Syndicate and Academic Council shall be reconstituted about every same time every 3 years, and the member of the authority shall accept ex officio hold office as member thereof up to the date of next reconstitution. Thus, on a plain reading of section 31, it is evident that same provides the Senate, Syndicate and Academic shall be reconstituted at about the same time every 3 years. Section 31 further provides that authority except ex officio shall hold the office up to the next reconstitution. In other words, the member of the authority have right to continue to the office only to the next date of reconstitution, and reconstituted Senate, Syndicate and Academic Council has to take place in 3 years. Thus, section 31 does not prescribe a tenure of 3 years in respect of a nominated member of a Senate, syndicate, and academic council. However, the aforesaid power cannot be exercised in an arbitrary so and so. Then para 12, my lord. The nomination to the Senate syndicate is made from the certain category of persons.
Up to 13. What
13.
you want to say is in 13.
Please, I'm grateful to Madam. It is well settled position, legal position. The rights created by a statute can only be limited or curtailed by the statute, and in the absence of some other competing right under the statute or under the Constitution of India, a right to a post cannot be claimed. It is equally well settled proposition. Doctrine of pressure can be impliedly read in a provision, and once doctrine of pressure is applicable, neither principle of natural justice or giving an opportunity before removal would arise. Then, my lords, 151. Last but therefore, just above paragraph 15, that your lordships were mentioned, General Clauses Act, my lords, paragraph 14, page 151. In the absence of specific provision in the Act for removal of a nominated member, my lords got it in middle of paragraph, page 151. It is pertinent to note, para 14, note that taking into account the facts applicants have been nominated to the post in question, they do not have any substantive right to hold the post. In the absence of any minimum tenure being prescribed in section, the doctrine of pressure can be impliedly read into section 21 and 24 of the Act. In the absence of a specific provision, in the absence of removal of a nominated members prior to the reconstitution of Senate or a syndicate, and 24 hours, read with section 61 and 21 of General Causes Act. Therefore, state government has the power to recall what, my lord, the nomination of a person nominated to the Senate syndicate even before the reconstitution of Senate or syndicate in entirety. So therefore, my lord,
Section 21 is different, my lord has put.
no, 21 of the Act, my lord.
21 of
The
General
Rajiv
Clauses
Gandhi
Act.
University.
Huh?
It
No,
is
General Clauses Act.
No, 21, 24 of the Rajiv Gandhi University Act read with 16 and 21 of the General Clauses Act. This earlier section 21 and 24 is of the university, 16 and 21 is of the General Clauses Act. my lord. Finally, just one other judgment, my lords. Can I request my lords to 236, my lords? No, I'm sorry, 235. my lord. The judgment starts at page number 225 at 235. my lord. My lords get 235. my lord.
Hmm? 235.
235. Just below emphasis applies. Such then is the nature of nomination. They are made without following transparent or objective process of selection of those weighing of such nomination. They hold office during the pleasure of the government, and therefore tenures lacking certainty or security of tenure. The intensity of review of any decision relating to making or unmaking of a nomination has thus to be low and, broadly speaking, limited to finding whether the impugned decision is vitiated bad faith, manifest absurdity, or improper motive. Allegation made by the petitioner do not, however, make out a case of interference on any one of the grounds indicated above. All that is stated that the petition is that the decision is politically motivated, which does not, in my opinion, even lay a proper foundation for any further inquiry by this court. If a nominations are made for political consideration, the same can be revoked with equal ease for similar consideration. There are no arguments alleging any corrupt motive against any instrumentality or contributory to the government decision to revoke nomination. The decision appeared to be a general policy decision taken to revamp statutory authorities by induction of new blood into the same. It is therefore difficult to dub the decision as one taken in bad faith or for improper motive. So therefore, Manoj, once then page 238, my lords, division bench judgment of the Bombay High Court. Insofar as security of tenure, my lords, what page para 13, page 238. 238, para 13, my lords, if I may request. The contention of petitioner that the tenure of 3 years has not expired cannot be sustained. There is nothing in the geo that sustain the indicate the tenure of 3 years for minimum in districts, the meaning of tenure ordinary prescribed in statutory appointment. Nomination of petitioner to the post without following competitive process and pure discretion and subjective satisfaction of the earlier government does not create or a vested right or entitlement in the petitioner to continue on their post. In fact, the existence of the commission itself is at the pleasure of the government. The very inception of the commission is by an executive order and can thus be dismantled by an executive order. The nomination of the petitioner to the post in question was also by an executive order of the government. Two can be cancelled by an executive order of the government. For this reason, the petitioner has no fundamental right or legal right to the post. Consequently, there is no requirement, any justification or giving an opportunity or hearing of the petitioner. The change in social policy followed by change in government is part of the democratic process, and the change in implementation of policy and programs per se cannot be said to be arbitrary or malefic. Then, Manoj, next page 240, paragraph 18, Manoj. Dr. Saraf, on the other hand, has relied upon a decision of the High Court of Punjab and Haryana in the matter of so and so. Similar question was considered by the Punjab and Haryana High Court, which held that appointment to high public offices like the chairman of the board commission, which are not made by following any competitive selection process for which no minimum tenure is prescribed or pleasure of the government and can be terminated at any time in exercise of doctrine without any cause. Well, therefore, even in these cases, 3 years have been fixed. Even in cases where 3 years are fixed, that power is. I humbly submit.
Week there 20, any date. 20.
The matter requires the matter itself is that serious.
Other matter also we have. In other matters, we are not.
No, chief. No, chief. His comment was against me. Who appears for the university panel council?
Then 11.
Serial number 59. 22nd.